The Committee on Parole is called to order. Today is 11/2026. The time is 8:57 a.m. Can you hear us over there?
Yeah.
He's on mute. Can you get yourself off of mute so we can hear you?
Okay.
All right.
Yes, sir.
All right. My colleagues on today's panel are Mr. Tillis to my left and Ms. Ledoux to my right. The panel today is at DOC headquarters in Baton Rouge with the staff here. Please introduce yourself.
Jasmine Thompson. Sherelle. Carla Williams.
Our remote location is the Natchitoches Parish Detention Center. Is there any staff in the room with you there?
No, sir.
Oh, okay. Your name is MCKARTNEY Young. Could you please introduce yourself with your full name and DOC number for the record?
Yes, my name is MCKARTNEY Young, DLC number 487976.
All right. Do you have a pro revocation questionnaire in front of you that you answered some questions on about foreign counsel?
I don't have the paper in front of me, but I recall.
Okay, can we put it on the screen? You recognize that as your signature?
Yes, sir.
Okay, based on those answers and the decision at the preliminary hearing, the probation and parole department determined you were not eligible for appointed counsel for this hearing. Did you hire an attorney?
No, sir, I didn't.
Do you want to proceed without hiring an attorney?
How long would I have to hire an attorney?
How long would it take you?
I mean, I'd have to get with my family members. I don't have any money, but maybe 30, 45 days, I'm gonna assume.
You have a court date of June 30th, right?
Yes, ma'am.
Okay, are you going to be, have a public defender in that case?
No, ma'am. My family hired a lawyer and an attorney for me.
Do you want to continue this case until after your court case?
Yes, ma'am. I would like to. I would like to continue it until the disposition of the charges.
Because the only reason that I would vote to continue is this is the only thing that you have against you at this point.
Yes,
And,
ma'am.
I'm going to just preach just a little bit. You're a parolee. You didn't get out on good. There's no
Yes, ma'am.
excuse for this. I mean, that's not what we expect. You
Yes,
understand?
ma'am. I absolutely understand.
I'm very frustrated to see a parolee before me. My vote would be to continue until disposition of the legal charges.
Tillis? I concur. And I'll concur also with the continuance to the outcome of the pending charges. So today your hearing has been continued.
Thank you, Ms. Ledoux. Unmute. Unmute yourself. Unmute. Shit, we go.
The Committee on Parole is called to order. Today's date is June 11th, 2026. Time is 9:11 a.m. My name is Danny Barra, serving as your chairman today. My colleagues on my left are Mr. Tillis and Mr. Adu on my right. We're here at DOC headquarters in Baton Rouge, and our remote location is Raymond LaBorde Correctional Center. Is there any staff in the room? Please introduce.
Deputy Warden Nikki Shinbear.
Thank you.
Patient Raven Heath.
Melissa Joshua Records.
Thank you. All right, and we have Mr. Smith. Mr. Smith, would you introduce yourself and give us your full name and DOC number for the record?
Yes, sir. Good morning. I'm Douglas Smith, number 373823.
All right. I'll give you a brief explanation of the hearing. I'm gonna read some information, ask you to verify it. I'm gonna give you a chance to speak. Tell us what you did that caused your incarceration and why you should be released. We're gonna ask the warden. We're gonna have some comments from the public. We're gonna have some district attorney comments if they're available, and then we're gonna allow your attorney to speak if you have one. So today we have for parole consideration Douglas Smith, DOC number 373823, who's a third felony offender who was convicted of DWI fourth, 2 counts, armed robbery, 3 counts, attempted first-degree robbery. And on October 26/01, 12/12/07, and 9/22/08 was sentenced to a total of 90 years hard labor in St. Tammany Parish. Got a parole eligibility date of December 2nd of 2026. Good time date of 10/18/2095. Full term date of 5/15/2098. Does that sound correct to you, Mr. Smith?
Yes, sir.
All right. So the first question is, what are you doing to cause yourself to get that kind of a sentence, and what have you done while you're there to make us think that you should be getting out early on a 93-year sentence?
Well, sir, I can't speak about my charge without going to my past, because my charge has everything to do with drug addiction and alcoholism, sir. So that stems from an early childhood tragedies that I had gone through. I also suffered some depression from those tragedies, and I also suffered low self-esteem because I suffered academically as well. So it was a fertile ground for an addiction, substance abuse problems. And if you will allow me, at this time, I'd like to address my victims.
Okay.
That would be Mr. Burton, Mr. Neal, Mr. Hamad, Ms. Hart, and Ms. Kuzan. I'm deeply ashamed that I allowed my selfishness and immoral, addictive behavior get so out of control that it affected you in such a profound way. And when I say profound, it's exactly what I mean, because I can only imagine the fear that you felt that day. No one should have to go through that, ever. I can only imagine the depth and the magnitude of that fear. Through programs, I've learned the magnitude of my actions that day extend further than just you alone. I understand now it's also your family, your mother, your father, your children, your co-workers, your employer. My actions that day affected not only you personally, but them as well. And I can only imagine how long that, do you still, affected by that today? I can only imagine. I don't know, and I'm sorry that I don't. What I've learned in prison is that my alcoholism, as I said, it stems from childhood tragedies that were hard to cope with, and low self-esteem that resulted in immaturity about the way I looked at myself, the way I looked at life. I've had a long time to reflect on that root problem. I've learned through programs and just maturity in general that everyone goes through hard times. Everyone suffers tragedy, and we all have to deal with it some way, somehow. And when programs like AA and Living in Balance, you hear testimonies of people that have gone through a lot worse than I have. My pain is my pain. I learned that pain is a part of life, and we have to be mature about how we react to that. Since then, I've become a man that's respected, a man that's sought for advice. I'm now, I've found my niche. I've found purpose in life, to whereas I've become a leader and teacher of men. Here at the board, I'm a welding instructor. And I've learned to teach not only welding, but I teach leadership skills, teamwork skills, of all walks of life, whether they're young, Christian, Muslim. All my students give me a lot of respect, and it's who I've become. It's who I identify myself as now. I no longer identify myself as that broken down, depressed addict in that cycle that was just continuously destroy me, and everything I tried. I've finally found God. I've found a purpose in life. I've found a confidence in myself, and I live it every day. I'm an example to all of my students. And by the time they finish the course that I can teach, levels 1, 2, and 3 welding, we've become good friends, and they all respect me. Like I said, whether they're young, it doesn't matter. I can relate to them all. And my faith in God, my ability to overcome my depression, to overcome my insecurities and my low self-esteem, the 20 years that I've spent in prison has made me uniquely gifted in helping others. And that's what I will and continue to do if you allow me some freedom. I have sons that can benefit from what I've learned about life and myself and addiction and tragedy. I have the Parole project. They're going to give me all the reentry tools that they have at their disposal. And my long-term plan is to hopefully parole out to Wiggins, Mississippi, Lumberton. Stone County is where I was born. It's my home. It's where my dad's entire side of the family lives. I have a job waiting for me there. I will be living with my dad's younger brother, who became a father figure to me after my dad's untimely death. And he lives alone. He's elderly, and he needs me there. And my cousin's willing to hire me as a full-time welder. Does equipment service, so he gets as much work as he does mechanic work. My support system out there is pretty big. They're all positive. Successful people, sir and ma'am, and I really hope you consider my sincerity.
Thank you very much. Thank you. Warden, can you tell us about how his behavior has been there?
He's only had 12 write-ups since 2001 in his record. He has completed numerous ICB and vocational programs. Like he said, he's a welding instructor for us here at Raymond LaBorde. He has taken anger management, living in balance. The only thing I would recommend if he is granted parole is that prior to that, he be enrolled in some type of long-term substance abuse program. As he said himself, he has battled with this addiction for most of his life.
Warden, may I ask, the 2021 write-up was for 14,
Yes, ma'am.
and that was after he took the living in balance and all of the other classes.
Yes, ma'am.
So that's a concern.
I agree.
Mr. Smith, can you tell us anything about that intoxication write-up on September 23rd, 21? After the treatment and all of that? Why was that happening?
Yes, sir. I died that day, sir, literally, sir, and scared the hell out of me. As I said, I had become very confident in myself, and unfortunately, I was still in a pity pool. Because here I was, finally, I felt mature, I felt I could be successful, but I had messed up my life so bad that I had a 90-year sentence, and I still felt hopeless that I would die in prison, and I was in a pity pool, sir. And what I learned that day is it's never, ever, not even a little bit, ever. And I love life, and I'm bigger than that cycle of destruction. I'm a leader and teacher of men. That's who I am now, sir.
All right. We also have several letters of support in your favor that came in that are part of the file. We also have several people in support who are here in the audience, and we also have 3 people who would like to speak. Let's start out with Mr. Andrew Hunley with the Parole Project.
Good morning, Andrew Hunley, representing Louisiana Parole Project, informing the board today that we have agreed to accept Douglas as a client in our reentry program if he were to be granted parole. Obviously, we decided to take Douglas on as a client in light of his positive record of rehabilitation. We're especially impressed with who he has become as far as a mentor and leader of other prisoners there, and the way in which he, especially with the welding trade and the number of people he's been able to assist. He has served right at 2 decades in prison, and he has significantly matured. We do agree with that. We also share everyone's concern that we want Douglas to maintain his sobriety moving forward. While we do believe that for the last 5 years he has been sober, part of our suggestion today would be, in light that his PED date's not until December, so even if the board were to agree to grant him parole today, he has time to continue the work. So we would ask that as part of his reentry plan that he be granted pending successful completion of a long-term drug treatment program, that obviously he would not be able to be paroled if he would not complete that program, that if granted parole, he would have to reside at Parole Project at an amount of time that we would be confident that he would have to display his continued sobriety for a time determined by the board before he goes to Mississippi. Our staff social workers did a social work assessment, substance abuse assessment that should be in his file where they gave some recommendations. But we want to make sure that he stayed with us long enough to work with our social workers to ensure that he has those tools, all the reentry tools, but also the tools to remain sober. And then upon that point, that we would apply for an ICOTS for him to go to his long-term residence in Mississippi. But we just wanted to let the board know we are confident that he is on the right path. We are confident that he is committed to his sobriety. We believe a long-term substance abuse program before he starting that before he meets that PED and having to complete it, even if it means completing it after that PED date, along with housing with Parole Project until a point that we're comfortable that he is working towards all of his sobriety goals, and then working with probation and parole to get an approved ICOTS addressed to Mississippi. Thank you.
Thank you. All right, we also have Tarzan Treadway, a friend who would like to speak. Want to go?
Thank you for your time. I've known Douglas for 40 years. I've witnessed him in good times and bad times. Bad times have always been directly tied to addiction, as he mentioned before. I truly believe that years of reflection on his mistakes and how he got there have led to a full understanding that drugs and alcohol cannot be a part of his future. He often regrets his mistakes, believe that ownership is crucial and what he knows. He has to know that and go forward. He's always been smart, hard worker, the leadership qualities and his determination to be successful. I believe this has been proven to be the case even while incarcerated, as he's earned multiple levels of welding certifications and he's now teaching. I believe he'd be a valuable asset to our communities. I know that Dale greatly desires to be a part of the boys' lives. So we talk about him often. If released on parole, he'll continue to have my support. And as you've seen many others, I'm confident that Douglas is prepared to follow the conditions of parole, continue moving in a positive direction. Thank you again for consideration.
Thank you. We also have Sarah Call, a friend who would like to speak.
Thank you for allowing me to speak on Douglas' behalf. I've known Douglas since middle school. We were friends throughout high school, and after that, we hadn't spoken in years. 4 years ago, we reconnected and began correspondence through email, phone calls, and visits. It's through these 4 years that I would like to talk about. Throughout the past 4 years, we have built a very strong friendship. I have visited him once a month. It's been during those interactions that I've been able to see a genuine change and sincerity that I believe can only be experienced by someone who has been truly humbled and broken. Not only have I witnessed growth in his character, but also a renewed mind and transformed heart. There has even been a transformation in his appearance over the years of our visits, which I believe is evidence of someone living with hope for a better future. He has tremendous grief over the lost years with his son, Douglas and Daniel, who are here today supporting him. And he desperately longs to reconnect with them as a father. He speaks of them often and earnestly hopes that they will be a part of his life. Instead of allowing bitterness and anger to grow during his incarceration, he has chosen to examine himself and to identify the root cause of his past behaviors. He has searched for the reason behind the hurt he caused himself and others. Taking complete ownership of his failures without excuses, Douglas has expressed sincere remorse and desire to redeem his life and restore what has been broken. The proof of his change is how he lives his life every day in prison as if he were free. He has established healthy habits and disciplines each day, including exercise, reading his Bible, and attending AA, NA meetings. He has earned respect from the students he teaches because of his work ethic, discipline, and strong leadership. Douglas is a very humble, hardworking, and loyal person. Everyone that knows him would agree. I believe he should be released so he can prove to everyone that change is possible when you take responsibility for your wrong actions and decide every day to choose to follow the right path. Thank you.
Thank you. All right, well, that's all the people we have speaking in support, but we do have several people in support here that I'd like to recognize. Miss Leon Lala, friend. Mr. Jason on Zoom, Mr. Jason Smith, a friend at headquarters. Tiffany Kilborn, a friend here at headquarters. Stacy Smith at headquarters, friend. Shelley Forcade, Kyle's mother, here in support at headquarters. Daniel Smith, son, here in support at headquarters. Douglas Smith, son, in support at headquarters. And Christopher Greico, a friend, in support here at headquarters. Rebecca McLeod, friend, and Randall Carl, friend. Opposition, we don't have anyone here to speak in opposition, but we have letters of opposition from the District Attorney's Office, the Sheriff's Office, and the Attorney General. So we have some law enforcement opposition.
I'd like to ask him.
Yeah, I have a couple of questions to go ahead, Mr.
Mr. Smith, I want to hear how you view your current state dealing with alcohol at this time.
It's my worst enemy in life, ma'am. I'm not afraid to say that. You know, at one time in my life, peer pressure tried to tell me that I had to run with the big dogs, but I'm not afraid to say anymore that I can't even handle a little bit, not at all. I don't need it. It's not something I identify with at all, ma'am.
Are you an alcoholic?
In the sense that I'm a recovering alcoholic, most definitely. My past shows you that I've struggled with it most of my life. We're always an alcoholic in the sense that we can never fool ourselves into thinking that we can drink in moderation or sociably. People like me, it affects us differently. It's like an allergic reaction is what it is. And I just can't handle, not even a little bit. So I won't even attempt to try.
Mr. Tillis, do you have any questions?
So you're attending AA meetings regularly?
Yes, sir. I have for the last 3 years. Yes, sir. Once a week, 1 week, and then twice a week the next week. And I have been for the last 3 years. Yes, sir.
So if released, you'd probably be open to have a drink or socialize with some friends. Do you think that will affect you?
I will not be open to drink and socializing with friends. I can't handle it, sir. No. What I have in place is my support group is alcohol-free and drug-free. The uncle I'm going to stay with, the uncles that are nearby, and the cousins that are nearby, we're all going to attend the same church. Mr. Jacob Smith, which is no relation, but he has agreed to be somewhat of a sponsor for me. And there's also in the town of Poplarville where I'll be working, there's a pastor by the name of Jeff Easterling. He has also agreed to be a sponsor to me. He has got experience with men coming out of prison and addictions, so he's a good sponsor for me, and I've already been in touch with him, and my sobriety program is in place, sir.
So you've been clean 5 years.
Yes, sir. Since that day, yes, sir. That was, as I said, I died that day, sir, and death has a way with giving you a perspective on life, sir, and I love life.
Thank you.
I'll move for an executive session.
I'll second.
Yeah, I'll second it. So go ahead.
Simmons,
Yes.
Burrow,
Yes.
Goodens.
Yes.
All right, without objection, the board is resuming session, coming out of executive session. And just give you one more chance to say anything that you want, that you left out, that you want us to hear before the vote.
Well, my sons, I ask that you consider they're victims as well. They've had to live with the stigma of my actions. I ask that you consider my release while I still got some good working years left in me, and I can still got some good positive years to spend with my sons.
All right. The case has been assigned to me. So I am gonna cast the first vote, and I'm gonna vote to conditionally grant you parole on completion of the long-term treatment that Mr. Hunley was talking about before you get out. That you go to the parole project for 1 year. And that you do their alcohol and drug program there. That you do AA and NA meetings weekly for the entire period of your parole. And that you not drive a vehicle that is not equipped with ignition interlock. If you drive any vehicle, friend's vehicle, any vehicle, work vehicle that's not equipped with ignition interlock, and we find out about it, I'm gonna give you back the rest of your 90 years.
Yes, sir.
That's my vote. It's only one vote. Mr. Dew?
Mr. Smith, you were convicted under the law previous to the time change where you can write back. When you can explain that to him. He can write back within 2 years. My vote is to revoke, to deny today. I need to see a longer period of sobriety within the prison setting. I would hope that there would be an opportunity maybe to do living in balance again. 20 years is a very long time, but the fourth DWI is one of the most indiscriminate crimes. Anyone can be your victim. And I'm sorry that your sons are victims, but we didn't make them the victim. You know, we're not the ones responsible for them being victims. And so my vote today is to deny.
Mr. Tillis?
Mr. Smith, I also concur with Ms. Ledoux. I think you need to, what got me was 5 years ago, you had a problem reoccur. And I think with some more time and classes, that maybe the next time you show up, it might be a lot better for you.
I think it would be, yes.
So, Mr. Smith, what that means is on a 2-to-1 vote, you've been denied your parole request today. However, we're gonna be watching you closely until your next hearing, which you can apply for. And we're expecting to see that there's no more contraband violations and no other violations, period. And some more classes done.
You have an opportunity now. You have what you would consider a setback. And now you have an opportunity to determine within yourself that you're going to move forward. Okay.
Yes,
Which
ma'am. Stay on the course.
Yes, sir.
And don't let the vote negate any of your good work that you've done. You've done some good work. You just need to do it for a longer period of time.
Yes,
This
sir.
will conclude our business today with Mr. Smith at 9:47 a.m. The Committee on Parole is called to order. Today's date is June 11th, 2026. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis to my left, Ms. Ledoux to my right. We're in headquarters in Baton Rouge, and our remote location is still at Raymond LaBorde Correctional Center. We're here to do a hearing for Mr. Johnson. Mr. Johnson, would you please introduce yourself with your full name and DOC number for the record?
Yes, sir. My name is Christopher Johnson, DOC number 472377.
All right. I'm going to give you a brief explanation of the process. We're going to read some information, ask you to verify it. We're going to give you a chance to speak and tell us what you did and what caused your incarceration and why you should be released. Then we're going to ask the ward some questions. We'll allow public input and we'll conduct a parole interview. So let's begin. Today we have for parole consideration, Christopher Johnson, DOC number 472377, who's a first felony offender who's been convicted of forcible rape, reduced from aggravated rape, and on August 18, 2003, was sentenced to serve 40 years hard labor, with the first 15 with no benefit of probation, parole, or suspension of sentence in Caddo Parish. Your parole eligibility date is December 28th of 26. No good time date available. And your full term date is 12/28/41. Does that sound correct to you, Mr. Johnson?
Yes, sir.
All right, go ahead and tell us, what do you do to cause yourself to get incarcerated, and what have you done since then that we would want to make us want to release you early?
But first of all, I want to thank the board for giving me this opportunity to express myself. The day of the incident was August the 3rd. You know, I was initially supposed to go get a video game from my friend. And I went over there, I stayed over to my friend's house for a little while. And I was playing the game and stuff like that. And the victim that was involved, which is JH, when they asked to go outside, and they didn't have nobody to go outside with them. So now initially I already had this paper. It was like a pornographic picture. You know, I was a kid, like it was a pornographic picture. And I went outside like that while they outside playing. I really tried to I would say I tried to go sneak and like relieve myself, because at the time, like I wasn't like sexually active at all. I'm just being honest. And the victim walked in on me like masturbating. And I tried to send the victim back outside, and the victim had said like they were familiar with what I was doing. So I kept fussing like, go back outside, go back outside. So what I did, I thought the victim went outside, but it came back in there and caught me like naked. Now I could have made the decision to actually like wait, being somewhere where it's privacy, but I didn't wait. So like I end up taking my clothes off, which I just had on some basketball shorts at the time anyway. And the victim was there, and I didn't never have the intentions. Like, I don't even know what was running through my mind at the time. Like, and all I did, like, I had this picture that I was looking at, and the victim was there, and the victim got naked as well. So what I did, like, I just masturbated. All I did was masturbated, and that's how my semen ended up on the victim. And when I left, I wasn't even thinking about it. Like, I just had left. I wasn't thinking about it. So they came to my house, and when they was explaining it to me, and like they showed me the semen and stuff like that, and I was like, man, I wasn't even thinking about that. So that's how the situation happened. It wasn't no more than probably like, the incident wasn't no more than like probably like 3 to 4 minutes at the most. But I actually felt bad about the entire situation. It's not because I got caught, because that particular day I could have made a better decision. And I knew that I'm a better person than that, but I just wasn't thinking, like I was a juvenile. I wasn't thinking about the damage that I caused nobody. I wasn't thinking about the families that was involved who actually loved me and treated me as a relative as well. So throughout this whole ordeal, I always felt a great remorse to where if I can go back to that day, if I can give my life to go back to that day, and that can restore useful life and useful health to the victim, that's something I do in a heartbeat, like to go back to that moment. If that'll take my life for them to sustain and thrive in society, knowing that this shouldn't have never happened to them. But
Mr. Johnson,
yes, sir.
the report I have doesn't read the way you're saying it. Did you strike the young child?
You want me to be honest?
I'd like for you to tell me the truth.
The honest truth is I did it.
You struck him, and you said that, you know, his mother said that you asked her, could you play games with him? And what got me was you were 16.
Yes, sir.
And he was a 6-year-old child. So please be truthful with her.
Honestly, yes, I struck him.
And you forced him to have sex?
Yes, sir.
Okay. You want to go with the warden? Or you want me to continue?
Well, he never told us yet. What he's gonna make us look bad.
Okay, tell us why you feel that we should allow you to be released.
Because of the transformation that I've done throughout my incarceration.
What kind of classes have you been taking?
I've achieved risk management class, anger management. I completed my said diploma. I got NSC forklift operating classes, CPR.
I saw those. Did you have any sexual abuse classes?
Yes, sir.
You did. Which ones?
Risk management. It has 27 factors to it. Risk management.
Okay.
As well as victim impact also.
Which one of those classes that you've been taking impact you the most?
Victim impact.
Victim, tell me about it.
What I love about victim impact, it shows you that your actions, how it can affect not only you, but all the parties involved, from your family to your community as well. And what I learned about that, what I didn't understand as a kid, like one decision can alter your whole entire life if you don't safeguard your thought process. And that's something that I had to grow over the years to really learn. And victim impact established that within me to where the way I look at life now, everything that I do, I say to myself, Chris, think about who it's going to affect. I left people out there to where I did serve the public, but I wasn't aware of it. And victim impact showed me how me coming to jail, I neglected elders that I helped out there as well in society. Where if I walk them to the bus stop to make sure they don't experience purse snatching or they don't experience no form of crime because I have a grandmother. So I was wondering, like, who protect her when she walked to the bus stop if I was there to do it? Like, who took her trash out in the morning where she thought she missed the trash man and I was there to do it? And I come from school and my neighbors thanking me for stuff like that. So I always felt good to be able to serve the public. I just made a mistake as a kid where I wasn't thinking, because I know that I'm better than that. And all the things that I've achieved in jail, I'm proud of it. Because I never experienced a lot of things out there in society that I experienced in jail. the psychological torment that I went through. Not only that, the mental growth that I experienced. So
What kind of guy is this guy? What's your comments on him?
Okay, well, he's had 14 total write-ups since he's been incarcerated. 9 of those have been sex offenses, aggravated sex offenses. And 7 of those were after he took risk management phase 1 through 4 in 2006. The last one was in 2021, I'm sorry. So that's what his disciplinary looks like. I think that he needs to take sex offender treatment again, as well as enroll in our sexual idolatry class that we offer here.
Good. Is it a problem getting him in there?
No, sir, it's not.
He hasn't applied for it himself?
He has not.
Okay, thank you, Wharton. We appreciate the work you guys do.
Along that vein, I will note that his static 99 score, which is a risk assessment tool for sexual behavior, is a 3, which is high, in my opinion.
All right. Today we have in support Sophie Reese from the First 72 on Zoom. Can we hear from Sophie?
Hello, yes, and thank you to the board for the opportunity to speak on behalf of Mr. Christopher Johnson. He reached out to our office a few months ago, and we've been in communication ever since about his plans for reentry. He's determined that the most supportive reentry plan would be in Shreveport. However, we still wanted to come on the Zoom and express our support for him. He has noted in our meetings with him that he's determined to be around positive people and that he understands that he would need to take it one step at a time upon his release. And he has a constellation of support both in New Orleans and in greater Louisiana. And so if he were to come to New Orleans, we would be happy to support him, to provide him with peer support, reentry case management, classes, job coaching, financial coaching, and all of the resources that we offer. And he just has expressed to us, and also through his classes that he's taken, that he is a hard worker and that he's determined to be successful upon his release, and that he's been very proactive in that process in terms of reaching out to us. I've also been in communication with the Muslim Reentry Initiative in New Orleans, who he's also reached out to and who are eager to work with him as well. Thank you for your time and consideration.
Are you offering him housing?
No, so we're unable to offer him housing due to his charges, which is why it was determined that Shreveport would be the best reentry plan for him.
All right, thank you. All right, we also have Terrence Wynn, a friend who would like to speak.
Hello, and thank you for this opportunity to speak on behalf of Chris. I've been knowing Chris ever since he got off the bus and came to prison, and he was always a young person that was trying to better himself, trying to right his wrongs. He's always expressed his sincere apology about his actions that brought him to prison as a kid. My organization, Pipes, we're offering all the support he needs. We have housing for him, we have employment for him, we have a peer support group to help him through whatever hard times he would have. But we have housing and employment for him. So in any way we can help him, we're gonna help him if the board gives him an opportunity to be released today. Thank you.
Thank you. We also have in support Kokima Johnson, cousin. You hear from Kokima? Go ahead.
Thank you for giving me an opportunity to speak on behalf of Christopher. I'd like to thank you guys for taking that time. Growing up with Chris, understanding the hard times that he went through, as a kid. And just before the incident at hand that took place, seeing what Chris was trying to do, I was the one that was in his life trying to help him make some better decisions. I myself, just a few years older, feel like I failed in that respect. But knowing Chris, having the conversations that we've had, he had just recently joined a program. He was actually in a program when he was arrested, to try to better himself and try to somewhat go into the Marines. Unfortunately, that didn't take place. I know the remorse that he's shown and we've talked through over the years. I like the board to know that he has support out here, both mentally and financially as well. We're here to support him, not only just through getting through housing, but also getting any type of counseling and things like that that is needed. We do know that it'll be an additional transition, coming from going in as a kid and spending over 2/3 of his life, or close to 2/3 of his life behind bars. I ask that you grant him grace. I do know that he had some incidents inside, but that was a child trying to grow up in an environment that's not conducive to anyone. But we, as his family, is here to help him get to that, and we want to see him home with us. We also want to see him be a great part of the community moving forward. Thank you for your time.
Thank you. We also have support from Essence Johnson, a sister who's on Zoom but not speaking. We also have Attorney Richard Spears, who's representing Mr. Johnson and will be speaking. Go ahead, Mr. Spears.
Good morning, and thank you for the opportunity. Ladies and gentlemen, I've been representing Mr. Johnson for a while. I looked into the legality of his juvenile situation and the conviction. And over that time, over maybe 7-8 years, I've gotten to know Chris. I will say before I start about legal stuff, on the personal level, when I first met Mr. Johnson a number of years ago, although he was an adult, he was still kind of mentally a child. And a few years ago, he made some kind of a switch. And we use the word remorse, but I'll add another word to what my observation of him is, and that is shame. And so when I was watching him talk earlier this morning, I just wanted to say, having spoken to him and gotten the truth out of him myself, he is not minimizing for the reason that most inmates do. If he did that, it's because he does have a sense of shame about this. And shame is something we don't talk about much, but I know that it weighs heavily on him. Having said that, I know that he, and I don't want to belabor what everyone else has said. He has a large family. I get calls from lots of family members with questions about his situation. He has an elderly grandmother who I understand part of his plan is that he's going to take care of her or help to take care of her. Mr. Johnson, Mr. Kokima Johnson, who just testified, has been heavily involved and been in contact with me about what can be done. There's no question that he was 16, he was a juvenile, and from what I gather, he was very immature even for 16 when all of this happened. And he's been involved in some other instances, but at some point he turned a corner, and I find that he does have remorse. His sense of shame and what he has learned and the punishment that he's endured at his young age has put him in a situation where I do not believe that he will reoffend. I won't lay out the law. I know that you all know the law about parole standards and so on and so forth. I too ask that you consider all of those factors that I just talked about and what everybody's talked about, and giving him an opportunity here.
Thank you, Mr. Spears. Appreciate you. All right. In opposition, we have the victim's grandmother, who's opposed to early release. We also have unanimous opposition from law enforcement. The judge is opposed, the DA is opposed, the sheriff's opposed, the chief of police is opposed, and the attorney general is opposed. So we do have opposition. Mr. Tillis, do you have any more questions?
No.
Mr. Ledoux, do you have any questions?
I don't have any questions. Thank you.
And I have no questions. So the time, it would be time to vote. Mr. Tillis, the case is assigned to you.
Mr. Johnson, after reading the case and then talking to you this morning and seeing that you admitted to what you've done, I appreciate that. Also, I realized that you were young when this happened. And all those when you were young would do some crazy stuff. But you've been incarcerated for a very long time and you still haven't changed some of your bad habits. I believe and I hope that you will continue moving forward. Today, my vote's going to be to deny, and I hope that you get some more classes, as the warden says, and you need to go ahead and sign up for those. And perhaps when you come up for us again, that I think it would be different. But you've got strong family support, but you've got to do what's right. You can't just come in here and talk a story. You've had 7 write-ups and they weren't the best write-ups in the world, but go ahead, say what you want to say.
I just wanted to say that, like, I went through a lot of transformation and I've changed a lot. But what I noticed wasn't mentioned. It wasn't mentioned that, like, if you look at my record, look at the times I had write-ups and the times I went without it. Like, for instance, I went like almost 5 years without a write-up. So I just stopped. My actions just stopped. Because it wasn't about the board, it was about me bettering myself, like preparing for society. I tuck my shirts in, I walk on the side of the yellow line, because I want to have a structured life that consists of obedience.
I believe that, and I hope you prove me that you have. I think if you get some more classes and continue on a path that you've been 5 years without a write-up, I'd like to see you with not any more write-ups. But at this time, my vote is going to be to deny. And I'm sorry, and I hope you do better. Ms. Ledoux.
Mr. Johnson, no one is negating the work that you've done while you've been in prison. However, there's some other things you need to do. Today, my vote is to deny. You can allow this vote to put you back, set you back. The warden knows that that's the potential that happens when we deny someone, but you can also take this opportunity to move forward. You have the opportunity to write back. I need to see a sustained period without sexual write-ups in your jacket. That's to deny.
Mr. Johnson, I also vote to deny based on the violent crime against a 6-year-old victim, the unanimous law enforcement opposition, and the victim's family opposition. I highly recommend, like the rest of the panel, that you take the additional sex offender specific classes that are offered and that you remain write-up free before you submit your name back for another hearing. Good luck to you. Today, your parole request has been denied, and this would conclude our business with Mr. Johnson at 10:22 a.m. Call to order. Today's date is June 11, 2026. My name is Danny Barra, serving as your chairman. My colleagues on today's panel are Mr. Tillis to my left, Ms. Ledoux to my right. We're at the Baton Rouge headquarters, and we're still at our remote location of Raymond Laborde Correctional. We're here to do a parole hearing for Mr. Turks. Mr. Turks, would you please introduce yourself by giving us your full name and DOC number for the record?
DRAMONT Turks, 331953.
All right, I'm gonna give you a brief explanation of the process. First, I'm gonna read some information, ask you to verify it, then we're gonna give you a chance to speak. Tell us what you did to get yourself in trouble and what you've done since that would make us want to release you early. We'll ask the warden to give us some input. We'll ask the public for some input. We'll ask the opposition for input. We'll conduct an interview and we'll begin. Today, we have for parole consideration, DRAMONT TURKS, DOC number 331953, who's a 5th class felony offender, who was convicted of attempted first-degree murder and first-degree feticide. And on 1/22/08, was sentenced to serve 50 years without benefit of probation, parole or suspension of sentence, plus 10 years consecutive in Bossier Parish. Your parole eligibility date is February 24th, 26, and your good time date is 2/21/51. Your full term date is 2/17/66. Does that sound correct to you, Mr. Turk?
Yes, sir.
All right. Go ahead and tell us what you've done to get yourself that type of a sentence and those kind of charges, and what you've done since then that would make us want to release you early.
Sir, on February the 18th, 2006, me and Tony Neal got into an argument, which I left the house to get away from, and went to the bar and did some drinking, did a little cocaine, and went to another location and did a little more drinking and a little more cocaine. And upon returning to my residence, I discovered another male, Gantry DeBose, in my living room with Tony Neal, enjoying each other's company. And at that time, I insisted that Gantry DeBose exit my home, and he did so. And me and Tony Neal had a few words, and then I left to try to calm down. And I went up the street and was telling somebody about it, and they offered me a weapon. And by this point, I was blinded by rage. I went back and I shot Gantry DeBose numerous times. Once in the head, once in the buttocks, and once in the shoulder and side of the face area with the 20-gauge shotgun shooting bird shots. Then I went next door to Tony Neal's house and kicked the door in, being dramatic, and chased her out the back door and shot her once in the upper area. I never found out exactly where, but in the upper area, and I killed her. And I took off running. And I immediately regretted my actions. I wish I could have taken the bullet back as it was being fired. I was madly in love with Neal, and we was building a family together. And I was just so blinded by rage that I couldn't think straight that night when I committed these offenses. And I never once even considered that she was pregnant with my child, no less, that night, until after I had committed these crimes. And I've never been afforded the opportunity to apologize to Tony Neal's family or Gantry DeBose and his family. But if ever given the opportunity, I would like to tell them how sorry I am for things that I've taken from them, the crimes that I committed. That I did a lot of horrible things, but I didn't mean any of them. I can only imagine the things that I put you all through. But all I can do now is, since I've been incarcerated, is try to follow my 8th step, which is making amends to those that I've hurt. And that's basically all I do during this incarceration, is try to help people to better atone for my actions. So I've taken all of the programs that this facility has allowed me to get in. And my biggest influential class was victim impact, because it taught me about the financial pain and my problems that my actions have caused. It's taught me about the emotional and psychological long-term effects of my crime. And I don't live that life no more. And through the programs that these classes have taught me, such as substance abuse classes, living in balance, you know, it's anger management. They've taught me how to better control my emotions and my feelings. And since I've made this transformation in my life and doing the right thing, what's the word? I do everything I can to be the best version of myself that is possible, sir. I've taken CPR classes so that I can better assist the people around me and help them with their medical conditions and medical issues. And I've done these things several times. I've recently applied to get in cat law CDL driving school if this parole board permits my release in Georgia. Now, I'm also prepared to enroll in line to continue my AA study to better control my addictions, because I know they led to a bunch of my problems. Is from my addiction that I take full responsibility and accountability for. And before I close this statement, I would like to reiterate how apologetic and sorry I am to the Niels family, as well as Gantry DeBose and his family.
I would like to hear from the warden, if you have any comments about this offender's conduct and rehabilitative efforts.
I do. He's been with us since 2009, and while here, he has taken every class we offer, as well as some vocational classes. So he's doing some good things here. He's setting himself up for when he does get out, where his reentry will be favorable. The only thing I would recommend is that, based on the things that he said to me yesterday in our interview and today, that if he is released, he be allowed to take some type of long-term substance abuse program to give him that extra step in moving forward if he is released.
Yeah, today we have in support who would like to speak. Stella Turks, the offender's sister. Would you go ahead and let us know what you got to say?
Good morning. I'm Sergeant First Class retired, Stella Renee Turks. I am the big sister of DRAMONT Turks. I call him Dingy because he's my little brother, and that's what we call him. I see a lot of changes in my little brother. He's actually helped me as far as family wise, dealing with family, you know, trying to make sure that I don't close my mind out to different family members and things. And so he's helped me with that. And I can see the difference in my little brother. And we understand that, you know, what he did was wrong. We do understand that. I do understand that we love that girl. I love her like a little sister. And it cannot change. That can never change. But I'm just asking the parole board to just hear us out and to see all the good things that he has accomplished while in prison. And I think he'll be okay. I think he'll be great as being released, because I've already talked to the truck driving place that he wants to get in. I've already talked to the lady there. She's already said that she'll accept him. I've already talked to a couple places that say they will accept him for the AA classes, and even if he needs boarding, but he will not need boarding because he will be if the parole board releases him, he will be living with me in my home in Georgia. And thank you for listening. Thank you for listening to us. God bless you.
Thank you. We also have in support the Keisha Turks cousin who does not want to speak. We have in support Jean Turks, a cousin who is not speaking.
I don't mind speaking.
You would like to speak?
Yes, sir, I don't mind speaking.
Go ahead.
All right, good morning, panel. I am Jean Turks. I've worked with the probation department in Texas in an administrative position for over 10 years. I call him affectionately Dinky. DRAMONT is my cousin. And I just wanted to let you guys know that his family is in full support of him. And we are ready to provide any type of support that is needed to help him be successful on re-entry into society. Also, I wanted to reiterate that it has been 20 years since he's been locked up. And, you know, the best that we can hope is that someone is penitent and that they are sorry and that they have learned from the crimes that they have done. That's the best that we could all hope for. I spoke to his mother the other day, and she was in tears at how penitent he was towards his crimes. And this has been 20 years ago, and he is still that way when he talks about the crime. He is very emotional, and she is always caught off guard by just how sorry he is for what he has done. Again, like I said, it's been 20 years. And in that 20 years, DRAMONT has had really no reason to believe that he'd ever be released, but the only thing that he has had is hope. And in that hope, he has used that to his advantage. And what he has done is, in that time, he has gone back to school, he has self-educated himself, he has become a trustee. And as you guys know, becoming a trustee is no easy feat, but he has been a trustee for about 8 years. 8 years he has been a trustee in this facility. As well, he has also created programs for other inmates here in this facility. On top of all of that, he also has a child. And as you know, little girls need their daddies and sons definitely need their fathers. He has a son who needs everything that he is today. All the man that he has become today, his son needs him today. So what I want you guys to know is that his family loves him. We're ready for him to be released. We're prepared with resources. He is penitent and he has a child that needs him. So with that said, we would hope that you individually, the individuals who individually make you each up, would allow him to have that opportunity. The one thing I can say is when I listened to the story that his mom shared with me about being penitent, he will never be able to escape what he has done. And not only can he not escape it mentally, it is clear that whether he is locked up here or set free, he is always contained in that prison. And the only thing that can let him free is you guys or the family's acceptance from the person that he hurt. That is so important to him. That's all that I have to say, and I hope that you guys side in his favor.
Thank you.
Excuse me.
We also,
Excuse me, board member. I do want to also reiterate that I do have a church family that is willing and ready to accept my brother, because I do work diligently in my church. And my pastor and the deacons are already aware, and yes.
Yeah.
that's-
all right, thank you. We also have in support D'Amica Davila, a niece who's present at RLC and not speaking. That's the people in support. Today, in opposition, we have opposition from one of the victims' mother is opposed. We also have strong opposition from the judge in the case, the district attorney in the case, the sheriff in the case, and the Louisiana Attorney General. Does anybody on the panel have any more questions?
Yes, I do. Mr. Turks, you're a fifth class offender, is that correct?
Yes, sir, ma'am.
And you committed this offense at around 34 years old?
At 30, ma'am.
Okay, and you have served 20 years
20 years and 4 months.
of a 60-year sentence. Was
Yes, ma'am.
this was a plea agreement? You pled down to this charge?
Yes, ma'am.
Because in actuality, we have 2 murders and an attempted murder. And so you pled down to 60.
Yes, ma'am.
Because they wanted a death penalty, didn't they?
They didn't specify the sentencing, but I had 1 murder charge, 1 feticide, and an attempted murder, ma'am.
Okay. I don't have any other questions at this time.
I'd like to go into executive session, please.
I'll second.
In favor?
Tillis,
Yes.
Byron,
Yes.
Ledoux.
Yes.
All right, without objection, we're back into regular session and we're ready to take the vote. Ms. Ledoux, you're assigned the case, so you vote first.
Mr. Turks, my vote today is to deny parole based on the fact that you have a strong history of violence and that you pled down. I believe that you're moving in the right direction, but I'm not prepared today to vote for parole. Thank you.
Mr. Tillis.
Mr. Turf, I believe you've made a turn for the best. And a lot of my decisions are made on what wardens say because they're with you most of the time. And I really hope that you continue on this path. My vote's going to be today is to grant.
All right. Mr. Turks, my vote today is also going to be to deny your parole request because not enough time has been served yet. 20 years with 3 victims, 2, 3, however you count it. There's a keep on the right track and apply again. So what that means is a vote of 2-1. Your parole request has been denied. This would conclude our business with you today at 10:51 a.m. Good luck to you.
Thank you all.
I'm not hearing anything.
Emily, you're not on mute, just FYI. We can hear you though.
Okay, I just figured it out. It was my
speaker. I'll mute me now, sorry.
My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis on my left, Mr. Adu on my right. Panel's over here at DOC headquarters in Baton Rouge, Louisiana, and our remote location has been moved to Elaine Hunt Correctional Center. Would the staff at Elaine Hunt please introduce yourself for the record?
Unmute.
All right, you should be able to hear us now. Warden Travis Day. Thank you.
There is credit assistant ward.
Christy LeBlanc classification.
Thank you very much. And we're there at Hunt Correctional to do a parole hearing for Mr. Keith. Mr. Keith, would you please introduce yourself and give us your full name for the record?
Yes, sir. Good evening, everyone. My name is AUDY KEITH Jr.
And your DOC number?
393128.
All right, I'm going to give you a brief explanation of the process. I'm going to read some information into the record, ask you to verify it. We're going to give you a chance to speak and tell us what you did to cause your incarceration and why should you be released. I'm going to ask the warden for some information on how you've been there. We're going to have public comments from people opposed and in favor of your release. We're going to conduct a parole interview. And your attorney will be allowed to speak. So let's begin. Today we have for parole consideration, AUDY KEITH, DOC number 393128, who's a first felony offender who was convicted of second-degree murder, reduced from first-degree murder on January 27th, 1998, and was sentenced to life in prison in Caddo Parish. Your parole eligibility date is not applicable. Your good time date is not applicable. Your full term date is a life sentence. Does this information sound correct to you, Mr. Keith?
Yes, sir.
All right. So the first question, general question is, tell us what you did to cause yourself to get that life sentence and why do you think you should be released now? What have you done since then?
Yes, sir. On this day in 1996, I set out to hang out with a group of friends. And where I typically went out to hang out to get away from the hostile environment that I was having inside of my house home with the abuse, both verbal and physical. Hanging out with Daniel and Christy Klein and Jason Gwynn, and we watched movies. He came up with an idea from a movie that he had that he wanted to rob his landlord and said he wanted to kill him. I didn't want him to do it. I said, no, man, you know, this is insane. So we just went along about our day like we normally do. We made a few errands, and upon coming back home to Danny's house and Christy's, Jason had departed us, and Mr. Rowland showed up a short time later, and Christy said he was here, and she went to the back of the house. Mr. Rowland had came up on the porch, Danny was coming down the hallway, and he pointed a gun at me, and he says, get the gun from behind the chair and shoot him. I was in shock. 16 years old, I didn't know what to do. I'd never been in a situation like this before. I just froze up. And I didn't know. He said, get the gun and shoot him. I got the gun. I shot Mr. Rowland. Danny comes to take the gun from me and went outside and stood over Mr. Rowland and shot him again. Then a short time after that, he told me to go to the truck and get the wallet out of Mr. Rowland's truck. I went and retrieved the wallet, brought the wallet back to him, gave it to Danny, he counted the money, and I had nothing else to do with the wallet. A short time later after that, Mr. Gwynn came over, and he said, did he really do it? I said, yeah, he really did do it. You know, and he took off running. And when he left, I left. So coming into the prison system at such a young age, you know, I was a young skinny kid, and I'm not asking for no pity or nothing on this. But when I came into the prison system, I felt that I had to adapt to this environment that I was coming into to survive. It was very, very hostile. There was a lot of violence going on at the time when I came in 30 years ago. And I got in a lot of trouble. I made a lot of bad decisions. And I felt that I couldn't be around the other people because of social orientation problems. You know, I didn't know how to adapt with it. So I got in a lot of trouble and I put myself in the cell blocks because I felt that I could more, you know, adapt to my environment inside of there. I didn't have to worry about dealing with people. Through the course of the years, I've made a few more mistakes along the way, but a lot of my disciplinary reports actually came from when I first come to the prison system. And I've taken self-help classes since then. I've taken victim impact, thinking for a change, pre-release, living in balance, phase 1 and 2. And I'm at the pinnacle of my life now where I've taken all the classes and I've become passionate, you know, and I'm sorry for what I did. And I realized the mistakes that I made in my life. And what I'm able to do now is I facilitate the classes. I'm giving back for the young generation that is coming in, where through the victim impact, I can identify, you know, looking back in hindsight, you know, I've heard previous hearings that, you know, I should have left. You know, I should have turned the gun on Danny. Looking back in hindsight, you know, maybe I should have. You know, I wholeheartedly agree. Maybe I should have. But at 16 years old, in that moment, I didn't know what else to do. I didn't have that thought process. You know, it was just a reaction. I didn't have the ability to process what was happening. So yeah, I should have left. But you know, thinking back about it, nobody thought that this was going to happen because he always made statements, you know, about doing various crimes and nothing ever happened. And even his own girlfriend said, you know, Audy, don't listen to nothing he's saying. You know, he's just talking. I was new in the neighborhood. I've only been there a couple of months, so I really didn't know him. So I had to, you know, I took what she told me and the rest of the people, you know, don't listen to him, he's just talking. I took it at face value. But now, looking back at it, yeah, I could have left and I should have left, but I chose not to because I took the advice of what she told me. And pre-release segment, I use that to give the people the tools where they can be successful upon their reentry into society. And the victim impact, I don't look at that as teaching, I look at that as an opportunity to share everything that I've heard the victims say. And it gives me an insight to teach for my class, you know, the impact that I had on these, the father that was lost, the husband, the Marine veteran, you know, he'll never be able to see his grandkids. And man, it hurts me to talk about this. You know, I'm nervous then, I'm nervous now, and I'm just sorry.
Mr. Keith,
Yes, sir.
I read your file several times and I read a little different. And what I'd like you to do is tell me the truth. Please tell me the truth. Whose idea was it to do this?
Danny?
It was Danny's idea.
Yes, sir.
But you shot him.
Yes, sir, I shot him.
Okay. And I realize you being a young guy, you know, can be influenced, but and what happened after you shot him?
After I shot him, Danny took the gun from him.
Did someone else shoot him?
Yes, sir.
Who was that?
Daniel Irish.
He shot him in the head, so he wasn't dead when you shot him?
No, sir, he was not.
Okay. Warden, could you tell us what kind of guy Mr. Keith have been, please?
Yes, so he's been at Hunt since August of 2022. His disciplinary record has been, he doesn't have one here. He's been a pretty good model inmate while being at Hunt. He works in the Houdat cafeteria here, and he does facilitate here. You know, looking back, he and I discussed his disciplinary history, and looking back through the years, you can see that a lot of his disciplinary stuff was done in his earlier years of being incarcerated, and it looks as though he has matured. Other than that, that's all I really have to say.
Do you think maybe he's turned the corner?
From looking at it and seeing the way that he is around here, the way that he interacts with individuals, I would say he's headed in the right direction.
Thank you, Warden. We appreciate your work. Okay.
I got a question. I'm pretty sure when I read that police report, it says there was 2 guns involved, a shotgun and a 30-30. You telling me now that there was only one?
No, sir, I'm not.
Can you straighten out where it doesn't match with the police report?
There was 2 guns involved, sir. Yes, sir. So Daniel Alvarez did have a 30-30. He was pointing a gun at me. He told me to get the 12-gauge shotgun from behind the chair and to shoot Mr. Rowland.
And then you shot him, and then you said he took the gun from you and went shoot him. He took your gun and went shoot him with a different gun?
He took the gun from me. He was trying to shoot him with that gun, sir, after I had shot him. And it would not work. And he put that down and retrieved the 30-30 and went out and stood over Mr. Rowland and shot him in the face.
And is that the story you told the police immediately?
Yes, sir.
I don't think so. Yeah. Okay. That's all the questions I had. We have in support Miss Adrienne Hutchinson with the Louisiana Parole Project. Would you go ahead and tell us what you got to say?
Absolutely. You didn't want to take the family supporters first? We do have one family member speaking in support, and then Andrew is, Mr. Huntley is also as well.
That family member's on the list, but tell me who the family member is.
Miss Connie Nolan, Mr. Keith's mother is gonna make a statement in support, as well as,
Say the name again, Tiny?
Connie Nolan.
Go ahead and speak.
Yes, sir. Good afternoon. My name is Connie Allen. I'm the mother of Audy Keith. Get the other, I'm a 4 kids. Over the past 29 plus years, I, along with my family, have continually supported him financially and emotionally. We have driven countless miles to visit him. We missed him being at home, just like the members of his family have been their loved one as well. Him being 16 when all this happened, it was hard on me. Harder on him, but it was hard on me. Because he was in high school, had a possible career in an NFL football player because he was good in sports. He was well loved by everyone he met. He always had a giving heart. If someone needed something, he was the person you would go to get it, because he just wanted that help. His dedication to his personal growth and rehabilitation while he has served over half his life here incarcerated. He has attained his GED. He completed carpentry school. He's taken several classes, which y'all already know that. But I just want to say in closing, because I really think I just hope something would help with this decision. But my family and I are very sincere in our prayers and condolences for the Rowland family, for all that you've endured, the friends and family, and the Blanchard community. I've prayed many nights cried many tears for the loss of Russ Rowan, for the children, for all they've endured, and them knowing that their children didn't get to meet their dad. That's hard on my heart as a mother, or even as a person. But I pray each of you can find in your hearts to see that Audie has done all that I think he possibly can to show his improvement and his dedication and how he could be a citizen in society. Upon his release, if that is the decision that is made, to enter back into society, I believe that would be a good thing, and I pray that it would be a good thing.
Thank you very much. All right, Mr. Hunley, you go ahead.
Andrew Hunley with Louisiana Parole Project here today to make the board aware that our organization continues to stand by what we have stated at Audie's previous 2 parole hearings, that if he were to be released, he is a client of our program. If he were to be released, he would have housing with us in Baton Rouge, in one of our properties. In fact, Audie understands that part of the agreement would be he would never be allowed to reside in Caddo or Bossier parishes. He wants the opportunity to start over in a place where he would not go back and potentially be seen or revisit individuals who've been harmed by his actions in the past. Part of the reentry plan would be, as you may have in your record, our employment and social work teams have done assessments. First and foremost, we have a plan with our social workers to ensure that all of those needs are met if he's comes home, and additionally, that our employment team is ready based on marketable skills he has to ensure that he has long-term employment and ability to support himself and become self-sufficient. But most of all, we're proposing a long-term plan that Audie would be with us. When I say long-term through transitional housing and post-transitional housing. And we would suggest that if at any point Audie sought to move into his own place, he would have to receive explicit approval by the parole board, but that would be nowhere in the Caddo or Bossier area. But long story short, we expect him to be with us long term. And I think the board understands what I mean when I say that, and that's with agreement from Audie. We're here today because of the Miller and Montgomery U.S. Supreme Court decisions, and then Act 277 of the 2017 legislature that gave parole eligibility to individuals like Audie who committed these sorts of crimes when they were under the age of 18. Parole Project has provided reentry support to over 100 of men and women who were in Audie's situations. Our organization has quite a bit of experience in the reentry of those individuals, and we take it very serious. We are confident, based on Audie's record of rehabilitation, that he would be able to successfully reenter as many individuals have before him, and our organization can handle that reentry support and has the resources and the capacity to do so. I would say that our organization has been impressed that, as the board's aware, oftentimes individuals face adversity when being denied parole hearings. After Audie's 2 last parole hearings, he has not regressed, but in fact has moved forward. Became a trustee. Now he's teaching the classes that he took before previous hearings. We would submit that we believe there is a sweet spot there for Audie because of his age and his ability to get employment now to support himself. We believe that he is well positioned to be successful if this board should decide to grant him parole. And we would stand by to answer any questions you may have about his reentry plan. Thank you.
Thank you, Mr. Hunley. All right, Miss Adrian, I'm gonna hold you for a little bit later. I got some other people. Miss Kathy Miller. I ask for executive session.
I'll second.
Monroe?
Yes.
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 All right.
So see when we get back, but you need to be looking at this. All of it. What was the name before it went on? That they wanted to talk to?
No, they said their names when they go into the executive.
No,
You call the name.
yeah, he called the name to speak, but
Oh.
I don't recognize it.
All right, board has concluded this executive session, and without any further delay, we'll hear from Adrian Hutchinson.
Good morning, committee. As we've heard and will hear, Audy's crime remains difficult for all participants in this hearing and anyone affected by his crime. So I did want to take time out to acknowledge that we do understand that revisiting this is painful. Before I go any further on an aside, I did want to direct the committee if they'd like to Exhibit 7 in my brief, which gives you Audy's guilty plea transcript. And about page 4 or 7 of that transcript, you will see the DA's statement of the facts, which does track with what Audy has described with Mr. Irish telling him to grab the gun, Audy refusing to participate a couple of times within the exchange. And then Mr. Irish pointing the gun at him and requiring and telling him to shoot Mr. Robin. And so that is in your Exhibit 7 of the brief that I provided for clarity. Audy is before this committee today seeking parole for the 3rd time, having listened each time to the comments by Mr. Rawlins' family and friends, having listened to the concerns of the DA's office, and having listened to what the committee would like to see in him moving forward. And after each hearing, kind of like Mr. Hundley said, Audy has incorporated what he heard into his life and moved forward with purpose. His first hearing was in 2021, in which the board asked to see a longer sustained record of growth and maturity by acquiring additional programming and remaining disciplinary infraction free. At the time, his last one was in 2019, so 2021 was a bit close. Since then, he's taken Thinking for a Change, the 24-week program, Victim Impact, several MCC ER classes in crew safety, construction management. He's done an Alcoholic Anonymous, sober living. He's done HVAC. So he's continued to do classes. He returned back in front of the board in 2024 and was denied due to victim impact. Audy understands that he can't do anything to alleviate the pain that he's caused to the victim's family. So in turn, he poured into others, hoping to catch them before they cause such pain. So what you'll see in his record now is he's a facilitator in programs like Better Men, where it's a faith-based program that teaches them how to be a better man for their community and their family. He teaches pre-release, which incorporates things like anger management, problem solving, and goal setting into how to incorporate that into release into society. He teaches Thinking for a Change, which we know helps others work through harmful thought processes and working on social skills. And most importantly, he teaches victim impact, right? It's a part of his ongoing commitment to personal responsibility for the crime he caused. And in each class, he has to revisit that crime and that pain that he's caused that family to hopefully deter others from going down that path. As Ms. Fitzgerald had stated in Audy's last hearing, he had struggled in prison, which he acknowledged his record wasn't great. He waited too long to seek out a positive and uplifting community intake program. That's why he pours into the inmates he meets now, whether it's in classes he facilitates, down the walk, or in the dorm, hoping to lessen their learning curve in a way that his was. And regarding her previous concerns with his learning curve if released, and whether that would look like prison, that's what LPP is here for, to long-term, to lessen that curve. As Andrew said, we've had about over 100 in his similar age bracket, but we're almost at 700 individual, formerly incarcerated individuals total. We provide a safe community for these individuals, for them to reintegrate back into society after decades of incarceration, teaching, leading, helping, and mentoring. This will be in the Baton Rouge area long-term, away from the Cattle Boulder area if he were to be granted parole. So today we hope, as stated by the District Attorney's Office in the last hearing, that Audy has earned the committee's grace and mercy, and you will provide him with a second chance. away from those he hurt the most and with any conditions this committee deems necessary. He'll be supported by his family, supported by LPP long-term to lessen that curve. And after having demonstrated time and time again, his remorse, his growth, his maturity, and his rehabilitation. Thank you.
Thank you. All right, I'm gonna now hear from opposition. We have Ms. Kathy Walker, the victim's mother, who would like to speak. Good morning, Ms. Walker. Go ahead and tell us what you have to say. You're on mute.
Yeah, okay, thank you. I had trouble getting it off. Good morning or almost good afternoon now. First of all, I'd like to thank the board. I know this is a difficult responsibility you have, and I appreciate it. And secondly, I want to ask for your patience as I get emotional and we rip open this wound again. But I just have something I'll do better reading. So a few weeks ago, I had a dream about Russ. I very vividly could see him in his overalls and his t-shirt, which he frequently wore while working in his shop. It was in a big metal building, just like the one we had behind our house. Russ was very creative and loved woodworking, as was demonstrated by the numerous rocking horses that he had built for so many friends. Matt was a young boy of 11 years old when his dad was killed. Because of his age, memories of his dad were limited. But he often observed his dad working in the shop. I recalled a few years later, Matt saying, "I sure miss the smell of sawdust." Later in the dream, I saw him pushing his daughter in her swing. He's sitting in the backyard. I can see it just like it was yesterday. Actually, I think I have a still shot of that. Again, in his overalls. I saw him sitting on the bucket beside her, talking to her and spending precious time with her. We did not know how precious that time would be. Our children's memories of their dad has happened in various ways. I tell them a story. I show them a photo, share one of his jokes, talk about his dog, and odd as though it may seem, even through maybe a smell of sawdust. Coincidentally, this weekend that I had the dream was by chance Memorial Day weekend. I believe that was not just a coincidence, but God's gentle reminder for me to honor him as not only a former Marine, but a brother, son, husband, dad, friend, and one of God's chosen people. This is a photo of him demonstrating what he was doing at the age of 17. Here I have the flag that was draped over his casket. The weekend that I had the dream, I told you was that, let's see, Russ's life was taken too early in a brutal way by AUDY KEITH. The coroner said in the case that shot would have killed him. AUDY shot him in the abdomen, watched him screaming in pain and pleading for his life. I can never get over that image. AUDY participated in the planning to lure Russ to the trailer where his life was taken. This was not a spur-of-the-moment decision. AUDY had planned it. You heard him say, he and Daniel and AUDY and everybody had planned it. He had plenty of opportunity to change his mind and stop this event from happening, but he chose to kill him. Russ did nothing wrong and did not deserve to have his life taken. He has 6 grandchildren that will never know him. This beautiful family. I'm sorry, this is kind of foggy, but beautiful kids. Can't see them. They'll never know him. I will continue to try to tell them the stories. I believe AUDY's original sentence was lenient, life in prison as opposed to the death penalty. He has shown what he's capable of, and I'm fearful of the safety of others if he is released and even on parole. I prayerfully hope that you will consider your decision.
Thank you for your input. We appreciate you coming. All right, the second person we have is Matthew Rowland, victim's son.
Good morning, board. And as my mother said, I appreciate you doing this once again. Unfortunately, here we are again, just a couple of years after our last time having to do this. Once again, it comes back around to haunt us and consume our days. I'll keep this short. I didn't write anything, but I'll say that the responses that I've heard up to this point, and the laying out of the events that he says happened that day, still don't show any accountability. He can. It can be said that it was always somebody else's fault, just like when he had his write-ups in jail. It's always somebody else's fault. It's adapt. He's running in the wrong circles. I can tell you it doesn't get any easier out here in the real world. There are a lot of different circles, and you're going to continue to surround yourself by those people and always pass the blame, never take accountability for your actions. Yet here we are as our family. We're having to deal with the actions every day, whether it's, missing out on memories, experiences, conversations. It doesn't get easier. And it hurts me every time we have to do this to hear the lack of accountability. You took a deal to save your life, and I believe that you are saving your life in jail. I believe that you are not remorseful. You're sorry, or he is sorry for his actions because where he is today, but not sorry for the family. I hear more remorse and sorrow from the attorney, from the parole program, or whatever thing that is that's going to bat for this guy. And from his mother. I don't get it from him. The responses he gave today were pretty much canned responses, replying to our last conversations we had here. Good. You're teaching classes in jail. Keep teaching them. Keep teaching them. Show people what happens when you do this. I still think there's a lot more growing to be done. I'm in opposition, and I'll leave it at that. I hope you find God, and I hope you find remorse, and truly look inside and understand what you've done. Thank you.
Thank you. We also have in opposition Miss Emily Cope, the victim's daughter, who would like to speak.
Yes, sir. Hey, thank you all for your time today. I, like my mother, am emotional, so I'll try to power through this. And I wrote something. I edited it as I was listening to everyone's to Audy's hearing or testimony this morning. Edited a little bit, and I want to say that my thoughts. I've recently listened to a book called The Change Agent, and it has kind of warped my thoughts a little bit on the prison system. I strongly believe in redemption. So with that, I'm going to start what I wrote. Over the years, I've struggled with the idea of forgiving Audy Keith for his role in my dad's murder. I've tried to put thoughts of Audy out of my mind because I do not believe he deserves my time, attention, or emotional energy. Holding on to the past acts like chains preventing us from moving forward with our lives. Unfortunately, each parole hearing brings these events back to focus and reopens wounds that will never fully heal. Once again, I am forced to devote time and thought to a man who has already taken too much from me. Yet here I am again, and here's my current perspective. God teaches us to forgive. Matthew 6:14-15 reads, "For if you forgive others their trespasses, your heavenly Father will also forgive you. But if you do not forgive others their trespasses, neither will your Father forgive your trespasses." I forgive you, Audy, for taking the life of my dad. Sorry. I forgive you because I do not want to be bound by the chains of the past, and because I want God to forgive me of my sins in life. However, my forgiveness should not hold value to you. I have been praying for Audy and praying that he finds God. I pray that Audy accepts responsibility for his actions he took and the role he played in the murder of my dad. It is God's forgiveness that Audy should seek. This is the second time I've attended this hearing for Audy, and unfortunately, I feel that I'm hearing the same red flags that I heard last time, a lack of personal accountability. I understand that Audy was a young, impressionable 16-year-old. I too now have a 16-year-old that I can understand the maturity level, so I can understand the maturity level. But I know that I'm raising my son to understand that we are accountable for our own actions, whether they be positive or negative, no matter the friends we pick. And you pick your friends. So you hang with friends that teach you and treat you that way, you're going to follow in their actions. And I'm raising my son to know better than that. And I hope it, hindsight, I guess what I heard a lot was hindsight, clarity. Well, we all have hindsight and clarity. But unless you take that, learn from it, and develop, you'll continue to repeat those same actions. While I appreciate that Audy seems to be taking the right steps forward, I am not confident that he has reached the finish line. From my perspective, true transformation requires both personal accountability and a profound moral and spiritual change. Until and unless Audy finds God and embraces those values, I do not believe he can become a respectable member of society. I am not confident that he has reached that point yet. That's all I have. Thank y'all for your time today.
Thank you. We also have Linda Rowland, the victim's sister, who's in opposition on Zoom but not speaking. And we have Leon Fitzgerald from the Caddo Parish District Attorney's Victim Assistance Coordinator, who will speak and is in opposition. Morning, Ms. McClarty.
Good morning to the board. Yes, I'm Leon Fitzgerald. I'm the director of the Victim Assistance Program for the Caddo Parish DA's office. And I'm today to strongly oppose parole for Mr. Keith on behalf of District Attorney James Stewart and my office. I was already planning to refer to Ms. Hutchison's exhibit number 7, which is the transcript of Mr. Keith's guilty plea. And she pointed out a few things, but I would like to point out that the assistant DA stated, and Mr. Keith admitted that it is true, that prior to the date of the murder, however, he had heard Danny Irish talking of killing Russ Rowland and taking his money and his truck. This was not a split-second decision, as the attorney refers to in her report. I don't buy that. I didn't think he would really do it. Even at 16 years of age, if you're consistently in the company of someone who is threatening to lure an innocent person over, rob them, shoot and kill them, and take their wallet and their truck, which is what he had said repeatedly, why in the world would you continue to put yourself in that situation? The day that the crime happened, when they all went to Walmart, Mr. Keith came back to that trailer home knowing that Mr. Rowland had been called and invited to come over. What did he think that Danny Irish had in mind? I don't buy that he did not know what was going to happen when Russ Rowland came over there. I would not treat an animal the way that these people treated Russ Rowland on the day that they murdered him. I'm going to be somewhat graphic, and I apologize to the family, but I just want to stress that the reports say that when the officers arrived on scene, there was a water hose running on the front porch, and they observed human body tissue and skull fragments scattered on the porch and on the ground nearby. Mr. Rowland had been dragged into the house at that point. Mr. Keith admits that after this murder, after shooting Russ Rowland in the abdomen and doing nothing to help him, he went to the vehicle and he took Mr. Rowland's wallet. Well, the keys were in the ignition of Mr. Rowland's vehicle. Wasn't that a gift? That Mr. Keith could have jumped into the truck, started it, and left and gotten himself out of the situation. He could have even gone so far as to call for help for Russ Rowland, but he didn't. He is not an innocent. He did not call 911 when he left the trailer and say, oh my God, get over here. I was just forced at gunpoint to shoot a man. There's a dead man on Tammy Lane and y'all need to get somebody out here to help him. He didn't do that. So not only did he participate in this horrendous, senseless murder of a human being, but he probably most likely could have prevented it from happening in the first place. But that's not what he did. So I agree with what the family said, that we are still not hearing total accountability on the part of Audy Keith. About the disciplinary record, I'm not going to beat the dead horse. Okay, we know it was terrible in the beginning. And I will grant that, you know, adapting to prison life when you're a teenager, it probably is difficult early on. But I looked at the graph that was provided by Ms. Hutchison, and I've looked at the disciplinary records, and I wanted to just point out that in 2015, he received 4 that year, which was pretty normal for him. And in 2016 was when he was resentenced to life with the possibility of parole. And so at that point, he knew that there was a chance. That's when he started making an effort to clean up his disciplinary record. He still racked up 7 more infractions between 2016 and 2019, but he does seem to be on a better path now. So when he was told that he needed to clean up his record by this board in previous hearings, he finally got serious about following the rules and being compliant. He couldn't follow the rules for 23 years just for the sake of following the rules. It was only when he thought that he might gain his freedom in return that he made it a priority to become a compliant inmate. That is not long enough to prove that he is serious about being on the right path. And by the way, some of his disciplinary write-ups were not, he didn't make his bed. They were contraband, like a cell phone and cigarettes, fighting, and sexual activity. I think he had 5 disciplinary infractions for sexual activity. So that doesn't just go away. So I'm not harping on the past. I'm harping on the man that Mr. Keith has been just within the past 10 years. 10 years ago, when he had the outburst with the judge at his resentencing hearing, because he thought he was going to get released that day. And then when he found out he was only getting resentenced, he cursed and outburst and had to be removed from the courtroom by 2 bailiffs. That was when he was in his mid-30s. You can't blame that on youth and that his brain wasn't fully developed. I'm sure that the board has read many of the letters that have been received. This family has been prolific. Every time one of these offenders comes up for any consideration, the board, myself, we're inundated with letters from loved ones, family, friends, the community at large. You can't go to the North Caddo area of Caddo Parish without running into somebody that knew Russ Rowland or went to school with him. And all I've ever heard are good things about him. These letters refer to him as a mentor, a Sunday school teacher, a Bible school teacher, a lifelong friend. That's who Russ Rowland was. And just like Kathy told the board, at 17, he was very young and he was going into the military. He and his buddy signed up and they left 6 days after they graduated from high school to go to California to serve in the Marines. And I think that says a lot about his character. And I think that we should respect our veterans, and for someone to serve their country in the military to end up leaving this world at the hands of 2 teenagers with a shotgun and a rifle is disgraceful. So I'm not going to go on. I'm just, as the family has already pointed out, how long it has taken to even hear an apology to them from Mr. Keith. It was in the last hearing in 2024 was the first time that he had said to the family, I'm sorry for what happened. In 2021, he said, "I'm sorry for what happened, even though I was forced at gunpoint." So Mr. Keith has a long way to go. I'm not saying never, but just because he's had his aha moment within the past 10 years, that does not mean that he can sustain clarity, a clean record, accountability, and that he is ready to leave the confines of prison and be in the real world. We are not convinced of that at all. This has been a contested issue by previous administrations and by current administrations. There's a lot of law enforcement opposition to this from the sheriff, the police chief, the district attorneys. So when Audy Keith pled to second-degree murder and a life sentence protecting him from the death penalty, that is the sentence that this office intended for him to receive, and that we maintain is still appropriate and well-deserved by Audy Keith. That is what he pled guilty to. That is what he knew that he was going to receive. So to say that releasing Audy Keith would deprecate the seriousness of Russ Rowland's murder would be an understatement. The hard truth is that Russ Rowland doesn't get a second chance at life, and his children and his sister and his loved ones don't get a second chance at having a father and a brother and all the blessings that that includes. The loss to Russ Rowland's family and friends is permanent, and we ask that Audy Keith's life sentence that he agreed to be permanent as well. And I thank the board very much for the opportunity to speak. Thank you.
Thank you. All right, as she said, we do have strong opposition from the district attorney's office, the sheriff's office, the chiefs of police, and the attorney general. Mr. Tillis, it's your turn to vote unless you have any more questions.
Mr. Keith, do you have anything else you want to say to us?
Apologize. I apologize again. I'm gonna continue on my path to what I'm doing, my great things that I'm doing to better myself. I'm never going backwards. I'm always going forward.
Thank you so much. Thank you so much. I'm ready to vote. My heart goes out to the victims. It's proven that when 16-year-olds can do some foolish things, I think 30 years, you've been incarcerated 30 years. I believe you've changed. I take a lot of weight from the warden and the facility there that says that you've changed. And so my vote today is going to be to grant.
You know that I was on your panel in 2024, and I was opposed to your release then, and I continue to be opposed to your release. However, Ms. Fitzgerald said something that I'm not going to say never. I'm not saying never, but it's not today. I like that you're facilitating courses, and I think that you need to continue on that path. But today, my vote is to deny.
And I'm going to concur with Ms. Ledoux for the same reasons. So, Mr. Keith, this means today your parole request has been denied. And this would conclude our business at Elaine Hunt Correctional Center at 11:55 a.m.
Send me your paper.
Committee on Parole is called to order. Today's date is June 11th, 2026. My name is Danny Barros, serving as your chairman today. Colleagues are Mr. Tillis to my left and Ms. Ledoux to my right. The panel today is at DOC headquarters, and our remote location is the Ouachita Parish Correctional Center. We're here for a revocation hearing on DERRICK Holmes. Would you please state your full name and DOC number for the record?
DERRICK Holmes, 512-138.
All right. Do you have a parole revocation questionnaire in front of you?
Do I?
A parole revocation questionnaire to talk about appointed counsel.
I don't know what that means, sir.
Okay, can we put it on the screen for him to see?
What that mean? They didn't send it, yours. He said they didn't see it. He said they didn't send one.
But you see that one that's up on the screen right now?
Yes, sir. Yes, sir.
Where it says offender, that's your signature? Where it says offenders on there, is that your signature at the bottom?
No, sir.
No. Okay, well, can you read?
Not too good, a little bit. Not too good.
Can you write?
I can write, sir.
Do you understand why you're here today?
Preliminary revocation here. A revocation hearing.
Have you ever been treated for mental health?
Yes, ma'am.
Are you currently taking any mental health, or when you were, right before you were incarcerated, were you taking any mental health medication?
I lost both my legs. I'm disabled.
Well, I'm going to go ahead and refer back to your preliminary hearing report that the probation and parole officers came and did with you there, where they had a preliminary hearing and it was found that you were ineligible for appointed counsel because you completed the 9th grade and that you are well oriented to the time and place of the proceedings, and stated that you are currently Ouachita Correctional and understood what his parole violations were. You also stated that he understood what a preliminary hearing was for and why we were gathered. Holmes indicated he could read and write the English language, but did not read for entertainment. He was up to date on current events such as who's the president in the Iran war. Holmes indicated that he watched television, primarily the news and Western. Holmes denied being under the influence of alcohol or any other medications, and taking illegal drugs or being under the influence might affect during this hearing. Holmes impressed the hearing officer as being intelligent and capable of participating in a preliminary hearing. And based on those answers there and the answers on that sheet that you don't recognize your signature on, they determined that you were not eligible for appointed counsel. So based on all of that, we're going to go ahead and proceed on with the hearing.
Two women, my parole officer and a woman came out there. He read some stuff to me for. He said it was for the preliminary hearing. She read some stuff to me.
Yep. And that's what we're getting ready to go over again, the same stuff.
Yes, sir.
They found, basically what happened was they found probable cause that there were violations based on the stuff they read you, and they sent it to us for a final decision. So we're going to go over that same stuff again.
Yes, sir.
All right. So it's alleged that you had violated the conditions of your parole by condition number 1. Your release date was listed as January 24th, 2026. But the Morehouse Sheriff's Office placed a detainer on you, so you were not released at that time. Holmes was transferred to Morehouse Jail for an unrelated matter. Holmes was then released from the Morehouse Jail on 2/3/26, but failed to report to the Monroe District Probation and Parole Office within 48 hours of his release. So how do you plead to that?
It was the ice storm. We had a bad ice storm going on around that time, and I got my letter incarceration from Morehouse right here. and it was a bad ice storm going on, and I'm disabled, and I ain't had it's no city buses in Bastrop, Louisiana, but it's city buses down there. When I got to Morehouse, I had no ride to get back, you know what I'm saying, down to Monroe, but I called and let them know what I'm saying, there was a bad ice storm was going on, and all the buildings, everything was shut down here. Everything was shut down during that ice storm. So that's why I didn't report in. That's what I was letting them know what was going on.
Who did you speak to down there?
Who I spoke to, I had called. I don't remember. That what I was telling them when they came out for the preliminary hearing. When they came out, I don't know the woman, know what I'm saying, in the office. I spoke with a woman and a guy. They told me soon as everything clear up, just go on, know what I'm saying, try to get down here the best way you can. Cause I don't have no ride or anything, I'm disabled. But when I'm down here, I use transportation.
All right, well, it looks like at that same preliminary hearing, when you pretty much gave that same information right there, Officer Miley gave clarifying information that Holmes was released from Morehouse on February 3rd and stated the Morehouse district office, the Monroe district office was closed due to the ice storm from January 26th till February 2nd. The Monroe district office was open on February the 3rd, the day that you're saying it was closed. So they're saying it was open, but you didn't show up.
That's when everything, that when it started back, you know what I'm saying? They started back open buildings and stuff up. And that's when I was trying to get back down here. That's when I was trying to get back down here. Cause I had no ride. And my mom is 70-some years old. She's 78 years old. But on 165 down here on the highway, the main highway, you can know what I'm saying, travel on that highway, we was just clearing up. But on just when my mom to get a ride, on the other side, it was bad over there. You can look it up on the news. It was real bad. It was real bad. When I got released from here, they took me from Morehouse. It was bad. The only way they could travel on just to come pick me up. That's why I had to wait so long for them to come and pick me up from Morehouse. I had to wait. I thought have been got out on the 20. I believe it was like the 29th. I thought have been got out, but I got out a couple of days later because the ice storm was real bad.
All right. So what we're talking about then is you pleading not guilty with your statement being that you didn't go because of the weather.
Yes, sir.
But you didn't go. So that's the issue parole officer had.
I was let them know. I called and I got my you can call the Morehouse and I got my paperwork right here. But I understand. I understand I didn't make it in.
Didn't go because of the weather, right?
Yes, sir. I understand it. Yes, sir.
So that's the answer there. You didn't go because of the weather. All right. Number 4, that you will not engage in criminal activity or associate with persons known to be engaged in crime. That's it. Officer Miley provided a sworn affidavit of probable cause for arrest warrant for DERRICK Holmes submitted by Officer Dramonte Caesar with the Monroe Police Department. Officer Miley read from the affidavit to provide information regarding the violation. On February 10th at 26 at approximately 11:03 a.m., Officer Caesar was dispatched to the Desired Street, 4305 Monroe, to the Smokers Express in reference to an investigation that was later determined to be a battery. Upon arrival, Officer Caesar made contact with the victim, Timothy Marshall, who was inside the Acadian ambulance unit. Marshall had a partially severed finger on his right hand, a bloody abrasion on his left knee, and dried blood coming from his nose. Marshall advised he did not know what happened to him. Officer Caesar then made contact with the complainant, Roosevelt King. King stated that DERRICK Holmes and Marshall were playing around outside. King advised that Marshall attempted to grab Holmes' hat, at which time Holmes pulled out a pocket knife and cut Marshall's finger. Officer Caesar made contact with Holmes and located a pocket knife in his pocket, which would appear to bleed blood on the blade. Officer Caesar also observed blood on Holmes' face and right shoe. Holmes did not appear to be injured and denied any involvement in the incident. Holmes was placed in handcuffs, transported to Ouachita Correctional, and processed for booking on second-degree battery. How do you plead to that one?
Could I speak on that, sir?
Either plead guilty with the statement or not guilty with the statement. Either way.
I plead guilty with a statement. I just try to plead guilty not guilty with a statement, I mean.
All right, go ahead and tell us what your statement is.
That was my first cousin, and we was out there, I'm gonna tell you the truth. We was out there playing with a knife, and we was just playing. This my cousin, we always play with the knife. We was just out there spinning the knife, who grabbed it first. And that's how he cut his hand. But the other victim, Roosevelt King, he was just a person just called the police. But my cousin, when the police got there, he told the police that we were playing. But the judge, I let the judge know, that's why the judge told me he would drop it down to a simple battery. He dropped it down to a simple battery, but I told him, you know what I'm saying, I wasn't trying to, know what I'm saying, to take this, but the judge said it'll be the best offer for today. I was like, would I get violated? He said you should not get violated, your parole should not get violated, because that was the cousin y'all was playing. That's what they wrote the statement for. But
So you actually pled guilty to a reduced charge of simple battery for condition number 4?
yeah, the judge told me, yeah. Yes, sir.
All right.
I've been trying to do the right thing, man. I'm not no bad person. I'm disabled. And like I said, I just got a house out there. My mom just got me a house out there. You know, I'm trying to just start paying go see them and my parole officer and start paying on my fees and try to get this over with, because I'm kind of hurting up in here, and it's like I need to get back on my medicine and stuff. And like they have the right medicine, this jail is not fitted for me up in here. There's no handicap, you know, sleeping on the floors and stuff. Jail is overcrowded. You know.
Okay, Mr. Holmes,
Yes, ma'am.
I know you live in Louisiana and everybody thinks, well, just a pocket knife. You realize a pocket knife is still considered a dangerous weapon?
Yes, ma'am.
Okay, so on parole, you're not supposed to have any dangerous weapons. And you had that, you know, and that's what happened. You start playing around and somebody gets hurt. It's one of the reasons you're not supposed to have dangerous weapons. I get it. It's just a pocket knife, but it's not just a pocket knife.
Yes, ma'am.
Okay, so it was only like 7 days after you got released that this happened, right? So you really haven't had any chance on other this happened, right?
Yes, ma'am.
Well, it looks like probable cause was found for condition number 1, and probable cause was found for condition number 2 at number 4 at the preliminary hearing by the officer that was the hearing officer there. And I found today that there's probable cause for number 1 violation and probable cause for number 4 violation, based on the fact that you did not report to the parole officer within 48 hours, and number 2, that you did plead guilty to a misdemeanor charge of simple battery while on supervision. So based on those 2 violations, you leave me no choice but to order that your parole be revoked.
What about the ICE?
Okay, Mr. Holmes, my vote today is to not revoke. I basically feel like you need to get a better start. And so I'm understanding some mitigating situations, but my vote is to not revoke, but you have a 2-to-1 vote today. So,
Based on a 2-to-1 vote, your parole today has been revoked. And this will conclude our business with you today at Washington.
You gotta wait till, yeah, you gotta wait till this, till you see the court people up there,
Yes,
the board,
yes, ma'am.
that's when it's gonna.
Oh, you mean to have a meeting?
Mm-hmm.
The Committee on Parole is called to order. Date 11/2026. My name is Danny Barra, serving as your chairman. My colleagues on today's panel are Mr. Tillis to my right and my left, and Ms. Ledoux to my right. We're at the DOC headquarters in Baton Rouge, Louisiana, and our remote location is Ouachita Parish Correctional Center. We're having a hearing on Mr. Roy Gremillion. Please state your full name and your DOC number for the record.
Eric C. Davis, 341756.
You're not Roy Gremillion.
No, I'm Eric Davis.
Okay, we got the wrong guy. Hang on a minute. Howard Blackman. The Committee on Parole is called to order. Today's date is June 11th, 2026. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis to my left, Ms. Ledoux to my right. Panels at headquarters in Baton Rouge, and our remote location is the Ouachita Parish Correctional Center. We're here to do a hearing on Mr. Roy Gremillion. Mr. Gremillion, would you please state your full name and DOC number for the record?
Roy H. Gremillion. My DOC number is 779700.
All right. Do you have a parole revocation notice in front of you, questionnaire?
Yeah. Yes, sir.
By that notice, you would P&P determine that you were not eligible for the appointed counsel by the Supreme Court guidelines. Had you hired an attorney?
No, I can't afford one.
Are you ready to proceed with that one?
Yes.
All right. I'm going to read you some violations against you and ask you for a plea. For each one, you may respond either guilty with a statement, or not guilty with a statement. It is alleged that you have violated condition number 4 as evidenced by the fact that you were arrested on 13126 by West Monroe Police Department for domestic abuse strangulation. How do you plead on that one? Guilty, not
guilty.
And then you have also another number 4. You were also charged with possession of controlled dangerous substance, to wit, contraband, while in the penal institution. How do you plead to that second number 4?
Guilty.
All right. It says the next court date on your pending charge is 6/24/26.
Yes, sir.
That's for the strangulation and for both of them together?
I guess I have no idea yet, sir.
Don't know if they're both together or not.
I have no idea.
All right. We'll go over condition number 4. It is alleged that you violated the condition of number 4, evidenced by the fact that you were arrested on 11326 by West Monroe Police Department for domestic abuse, battery, strangulation. You also charged with possession of drugs in a penal institution. Officer Tolliver provided the following testimony on January 31st, 26 at approximately 7:56 p.m. Officer L. Hoot of the West Monroe Police Department was dispatched to Elby Street in Monroe in reference to a physical disturbance between Gremillion and a female victim. The victim stated Gremillion grabbed her by the neck with both hands, slammed her head to the ground, and then drug her out of the vehicle across the ground. Officer Huth observed injuries on the victim to support that statement. Gremillion denied the accusations. Gremillion was arrested and booked on the offense of domestic abuse strangulation. Let's just take that one separately. Let's talk about that one first. That's what they have labeled as A. Tell us your version. You said you're not guilty, but victim says you are.
Yeah, the victim went to the crazy hospital and all that too, or everything. She had mailed in paperwork things that her medicine wasn't right and all type of other stuff too, or whatever. I'm just waiting to go to court to present that stuff, information.
So you're saying the victim's recanting her story now?
Yeah.
You have proof of that with you today?
Now, my lawyer should have it. My public defender should have it. She had mailed it in or whatever. She mailed it in to the lawyer.
Okay, so how did you meet this victim?
Sober living.
Huh?
He was in sober living, and we was both working on a job site together.
So you were both in sober living.
Moved out, yeah, we got a house together and all that stuff, and then we went from there, you know.
Oh, maybe that wasn't the right decision to move out of sober living, huh?
Yeah. Yeah.
Doesn't sound like you were sober when it happened.
Yeah.
Well, her injuries are consistent with the report indicating that there was some violence. Even if she recants, you realize that we can still revoke you.
Yes, ma'am.
Okay.
All right. On violation, the second part of it, on March 10th at approximately 12:30 a.m., Deputy Bosworth with the Ouachita Parish Sheriff's Office was conducting a strip search of inmate Gremillion at the Ouachita Parish Correctional Center. Deputy Bosworth observed a white ball of paper wrapped in a small, clear baggie in Gremillion's right hand. Deputy Bosworth inspected the balled up paper and discovered suspected methamphetamine inside of it. GREMILLION denied possessing the suspected methamphetamine. GREMILLION was arrested and booked on the offense of possession of CDS Schedule 2 in a penal institution. Tell us about that one.
Got it right there on your paper.
You what?
And you got it right there on your paper in front of you.
Basically, you had methamphetamine inside the paper.
Yeah, they asked me already if I was plead guilty to that. I said, yeah.
All right. Do you have anything else that you would like to bring up or talk about before we take a vote on this one?
No, sir.
All right. Well, the case is assigned to me, and I cast the first vote in this case based on the fact that you admitted to possession of drugs in the penal institution and the evidence in the police report about the domestic abuse. I found that you violated condition number 4 and order you to be revoked.
My vote is to revoke based on criminal activity during probation.
And my vote also is revoke on violation number 4 and 4.
Yes, sir.
All right, this means that by a unanimous vote, your parole has been revoked, and this will conclude our business with you at Ouachita Correctional at 12:42.
That's it.
All right, today's date is June 11th, 2026. My name's Danny Barra, serving as your chairman today. My colleagues on the panel are Mr. Tillis to my left and Ms. Ledoux to my right. We're paneled at headquarters in Baton Rouge, and our remote location is the Orleans Parish Prison. We're there to do a hearing on Mr. Eric Davis. Would you please introduce yourself with your full name and DOC number for the record?
Eric C. Davis, 341756.
All right, Mr. Davis, your case has been assigned to Mr. Tillis. Going to go ahead and turn it over to him.
Good afternoon, Mr. Davis. How are you?
I'm hanging in there.
Good. I got some violations that I'm going to read. And when I read them, you can answer them with guilty, not guilty, or with a statement. Okay? You have violation number 3. You failed to provide your parole officer with a valid residential address. How do you plead? Guilty, not guilty, or with a statement?
Not guilty with a statement.
Okay, tell us what happened.
I was homeless and I was bouncing around 2 different homeless shelters. From what I recall, I did give him, I might have gave him 1 or 2 addresses. And the address that I gave was 2239 Poitiers Street. That's where my mail went. And that was the only valid address that I could give him. Is this homeless shelter.
Okay.
That's where my mail was going.
All right. On or around 1/1/26, you engaged in criminal activities when you were committed to a crime of disturbing the peace and a criminal damage to property, which led you to be arrested by the New Orleans Police Department. How do you plead? Guilty, not guilty, or with a statement?
I plead not guilty.
You want to make a statement?
I didn't commit this crime, and this charge was dismissed, and I have the proof right here in my hand.
Okay. What is it? Can we see it, please? What's the proof you have? Can we see it?
Dismiss this charge.
They dismiss the charges?
Would you like to see the paper?
Okay, that's good. That's good. That's good. Rule number 4A, on or around 2/17/26, you engaged in criminal activities when you committed the crime of aggravated assault, 2 counts, simple crime, criminal damage to property, which led to your arrest by the New Orleans Police Department. The aggravated assault charges were refused by the New Orleans District Attorney Office on 3/19/26. How do you plead?
Not guilty.
You want to make a statement on that?
If I could speak to the procedural aspect of this, my name's Grace Perrette and I work with the Public Defender's Office. I'm his attorney. I'm happy to do it at my time. But
Sure.
there were discrepancies in the incident reports. There were multiple versions of this incident report, and I'd just like to speak to the allegations. I can do it now or at my time. It's up to the board.
Go ahead. Please go ahead.
Yeah, so again, my name's Grace Perrette. I have had the pleasure of representing Mr. Davis on the charges, on the refused charges that were alleged from February 17th, 2026. The version of the report that I was given when his case began alleged simple assault. There was 1 count of simple assault and not 2 counts of aggravated assault. I also, once Mr. Davis's charges were refused, I had my investigators submit a Public Records Act request to the New Orleans Police Department for another copy of the incident report to confirm that there wasn't a different allegation, but the charges that were submitted to the Orleans Parish district attorney's office was 1 count of simple assault. The item number that I have associated with the only magistrate number that was submitted to the district attorney's office is B16390-26. That version of the item number specifically does not mention any allegations of aggravated assault. It does not mention any weapons. It states specifically nothing physical happened. And at the bottom of the report, I don't know which copy the board has, but at the bottom of the copy that was both provided to me at the beginning of Mr. Davis's case and the version that, so the version that is in the official file at the district attorney's office, as well as the version that I requested separately from the Orleans, from NOPD, states, it shall be noted that the correct signal shall be a signal 38 relative to simple assault. I don't know what happened in this situation. I don't know if the alleged victim changed her story and NOPD rewrote the report to reflect that. But magistrate number 625549, which was the only case that was submitted relative to the allegations against Mr. Davis, was, as Mr. Davis said, refused, but that case also was only for 1 count of simple assault. So I'm not quite sure where the discrepancy happened, but as far as I know, the official record from both NOPD and from the district attorney's office is that on February 17th, Mr. Davis allegedly committed simple assault. And then again, those charges were refused.
That's on 2/17/26 that you're talking about?
Yes, sir.
About the charges on 1/1/26.
Those charges were in municipal court. We were not representing Mr. Davis at the time. I believe that those charges I am aware that those charges were null prost, were dismissed by the city attorney's office. But Mr. Davis was not held from my understanding, this was a arrest and it was almost immediately null prost and then he was released. I have been representing him since his arrest on the 17th on those charges that were placed in Orleans Criminal District Court as opposed to municipal court. Does that answer your question?
Are you telling us that the charges that were in under docket number 26M00002 that had a trial scheduled for 5/11/26, that those charges are dismissed?
Those have been dismissed. I wasn't aware that they were set for trial. I thought they had been dismissed earlier than the 11th. But I did confirm as recently as several days ago with the attorneys who were in municipal court that those charges have been dismissed. And I'm happy to get documentation of that if needed and submit it to the board. We just didn't represent him on those charges, so it's more difficult for us to get all of that documentation in place.
So based on what you're telling us, it's your belief that all the charges that he had pending in both municipal and whatever other court you were talking about, all of them are dismissed? Everything?
Yes, and I can confirm that. I have seen the documentation. I just don't have it in his file because it's a different process of requesting the records. I'm happy to supplement the record here with that dismissal if needed after the hearing. But I can confirm that all of those charges, both the municipal and then the parish district, which is the one that I represented him on, the February charges, those have also been dismissed.
That's the ones with the dangerous weapon?
The dangerous weapon charge, I believe, was some variety of reporting error. Those were never even brought to any prosecuting authority.
Sure.
The version of the report that is in the official record at Orleans Parish Criminal District Court states that the incident on the 17th, it shall be noted that the correct signal shall be a simple assault.
Okay.
So I don't know if there was initially a different report generated by NOPD and then not submitted to the district attorney's office, but an aggravated assault charge from February 2026 was never even submitted to a prosecuting authority.
That's a lot of charges that just went away.
I don't know what has been going on with this complaining witness. Candidly, there's There's 3 charges total, from my understanding. There's a disturbing the peace and a simple criminal damage to property, both dating to January 1st.
And then
then
a
there's-
simple assault,
There's the simple assault from February 2026.
not 2 ag assaults.
Those aggravated assaults are nowhere in any court record.
They're just in ours. Okay.
And I don't know how it made it to your record. I have requested those records from NOPD. They provided me with the Public Records Act copy, which is a simple assault, 1 count from February 17th, 2026.
Okay, any more questions? All right, we'll move on to root violation number 6. You failed to provide your parole officer with proof of gainful employment. How do you plead?
Not guilty.
You want to make a statement on it?
Yes, sir. I was homeless and I was bouncing around from shelter to shelter, and I didn't have any bus passes, anything to get around. And I was going to the daily report center, and they were trying to help me find a job, but I had trouble getting there. That's it.
Did you communicate with your PO officer?
The parole officer gave me a phone and it didn't work, and I'd be stuck at the mission at another shelter, and I couldn't get there, and I couldn't get in touch with the man. And I would basically see my parole officer at that daily report center. I think I might have seen him once at the shelter. At the shelter, you gotta be in there at 4:30 in the afternoon, and they throw you out at 5:15 in the morning. So evidently, when he came to come see me, I wasn't there. I didn't hang around there. That's the only explanation I can give.
Okay, so that would justify you failed to parole officer with the address at the shelter. So you gave it.
Yeah, I gave him that address.
And violation number 10, you failed to make any payments toward supervisional fees in the amount of Louisiana Department of Corrections in the amount of $189. He was $65. How do you plead guilty, not guilty, with the statement?
I plead guilty with a statement. I didn't have a job and I wasn't receiving an income. I was getting ready to get my partial Social Security. I'm 63 years old.
Okay.
I didn't have a job and I couldn't pay.
Jerry, Danny?
I'm willing to change.
Well, okay, let's go with first 72.
Yeah.
All right, at this time we'll hear from first 72, Sophia.
So good afternoon, and thank you to the board for the opportunity to speak on behalf of Mr. Eric Davis. We are eager to work with Mr. Davis upon his release, and we've been in contact with his team at the Orleans Public Defender's Office about how we can best support his reentry process. And Mr. Davis also was previously a client with us at the First 72 Plus prior to his arrest, and so we would be happy to welcome him back and provide him with our services. He would be assigned a reentry coach, a formerly incarcerated case manager that would guide him through our case management plan by assessing and responding to his unique needs. And this case manager will also be able to work with him to complete any behavioral health referrals that are needed and would be a consistent source of mentorship, guidance, and encouragement for him. He would also benefit from our weekly reentry 9 Steps to Staying Free class, which invites clients to participate in open discussion surrounding sticking to their goals, mental health support, managing their sobriety, handling their emotions, and much more. So he would really benefit from our culture of us helping us and peer support. He would benefit from a community of formerly incarcerated individuals who are committed to supporting each other in the reentry process. And so our peer support classes and case management will work in tandem with the plan that his client advocate has put in place for him to participate in grief counseling and managing his emotions to understand his experience. And our Director of Economic Empowerment will also work with Mr. Davis to help him open a bank account and budget his income. And we will also be happy to provide him with our other wraparound services, including clothing, proper identification, social security registration, SNAP benefits, medical assistance, employment assistance, and help him look for supportive housing. And should you determine that Mr. Davis requires any additional support services, we will gladly work to provide those services as well. Thank you for your time and consideration.
You said help him look for housing, you're not gonna provide him housing?
We would not at this time, we wouldn't provide him housing, but we would be happy to assist him in finding housing that would meet his needs.
You mentioned that he was a client before his arrest.
Yeah, so he had participated in our public benefits assistance. We had just assisted him in getting his birth certificate and things like that.
Wait, so when did you become aware of Mr. Davis, and what time period did you assist him?
We had assisted him back in 2025.
So he paroled October 6, 2025.
October 6th. Yeah, so
I can step in here. I believe he's had a technical violation and has been kind of in and out over the past year or so. So he did have a period of time where he was incarcerated in 2025. He went to First 72 and then has been reincarcerated since February 2026, is my understanding.
So it didn't work the first time he went through First 72. So the benefits that y'all provide did not help him achieve an independent life with all of the tools necessary to keep him free from incarceration. Is that correct? First 72.
So we had assisted him with public benefits, but not our other wraparound services. So we would be able to provide him with more intensive case management from our reentry coaches, as well as our peer support classes, our assistance through our economic empowerment coach.
So why does he not qualify for housing?
Sorry?
Why does he not qualify for the 90 days housing?
We just in discussion with the public defender's office, we were told that he already had qualified for housing, or he already had a different housing plan. All that Wanchi and the public defender's office discussed that more, but we were told that he already had a housing plan in place.
Okay, so Wanchi may be able to provide clarification on that.
Correct. I can provide some more clarity once the board decides it's my time to speak.
Go ahead. Let's hear what you have to say, please.
Yeah, thank you so much. Good afternoon. My name is Wanchi Kong. I'm a client advocate here at the Orleans Public Defenders. I've been working with Mr. Davis since his arrest in February, and as y'all know, that case has since been refused, and we've been working on a plan to make sure that he can be compliant with the conditions of his parole. So I want to answer to all your questions, but I also want to provide a little bit more context about who Mr. Davis is, which I know is detailed in the parole packet, and Mr. Davis and Grace can talk about as well. But I do want to mention that just in the backdrop for Mr. Davis, before this arrest, he had been homeless for some time. He was dealing with some pretty intense and tremendous grief after losing both of his parents between 2022 and 2025, and was just overall a very vulnerable person dealing with both just like the grief of losing family and the destabilizing factor of not having housing. In the time of him being homeless, you may be aware that in Orleans Parish and across Louisiana, there's something called a permanent supportive housing voucher. It's often abbreviated as PSH, so you may have heard of that before. That comes through Unity. And to qualify for that kind of voucher, which is subsidized housing, particularly for individuals like Mr. Davis, right, who is elderly, has a disability, and, you know, does not have any ability to achieve independent housing with without this level of support and housing case management, it actually takes a year of documented homeless time to even qualify for that voucher before being placed in a unit. Obviously, that presents a lot of challenges. It's not the easiest. let alone have documentation of it. And I just want to mention that Mr. Davis actually did qualify for this voucher right before this arrest. And he and his housing case manager at Travelers Aid, Christy Arsenault, had been looking for a unit. And unfortunately, as a result of this incarceration, he's actually lost that voucher, but is eager to work towards it again because we do think that this is the most stable and permanent solution for him. We believe that searching other options like a group home won't actually present long-term success because ultimately he won't be able to pay for those housing options. And so Christy Arsenault has already confirmed with me that she is still going to work with him and provide housing case management so that he can work towards this voucher that he once did qualify for prior to that, that system involvement. So that is the housing plan in place at this time. Mr. Davis and I have also spoken about alternative options. As his client advocate, I'm going to be available throughout this whole time of his reentry if we need to pivot. So other things that we have discussed before outside of the PSH voucher would be options such as sober living homes, speaking with First 72 about the transitional housing program, etc. But at this time, Mr. Davis and I and Christy Arsenault have all determined that the best course of action right now is actually to work with Unity and Travelers Aid so that he can get that long-term subsidized housing plan. So I do want to just speak to that aspect that y'all had some questions about.
Wait, and that would it be available immediately upon release?
Unfortunately, no, because he lost that voucher because of this incarceration. He has to work towards it again. But because this person already knows him, Christy Arsenault, she's going to work with him to make sure he's supported. And the plan is that he would stay at shelters such as the Oz or the Mission, because the only way, again, to qualify for this voucher is to stay at a shelter or be street homeless. There is no way that a person can stay on the couch of a friend of theirs or stay in a short-term hotel stay or go to a transitional housing and have that count towards the voucher. That's unfortunately just not the way that it works in terms of counting for documented homeless time. And so all of those solutions would be great for the short term, but actually wouldn't be best for Mr. Davis because he would have no ability to afford that.
Okay, gotcha.
And so the next part I want to speak to, oh, my apologies, you had a question.
Get a job?
Yes, and that's the next part I want to speak to, and that would be about income, both for paying for housing, surviving, and also, paying any of those supervision fines and fees. Mr. Davis is 63 years old. He's living off his Social Security retirement benefit, and this benefit, while small, would be enough to sustain his housing and help him, work on a payment plan so that he's paying some amount to his supervision fines and fees. But on top of that, he also does have a disability and does not get disability benefits at this time. And so I've referred him to work with a program called FAIR. That's short for Financial Access, Inclusion, and Resources. And this is specifically a re-entry program through Disability Rights Louisiana that works with clients who are coming out of incarceration so that they can enroll in SSI, manage their SSI, seek some part-time employment that's not going to interfere with their benefit. As you may know, if you are getting any kind of social benefit, working full-time might actually interfere with that benefit, which would keep, many individuals such as Mr. Davis in poverty. And to add on top of that, he is elderly and does have a disability. And so for income, we would have him on various benefits with assistance from Carolyn LeBrain Tilton, who's the case manager at Disability Rights, who has attached a letter of support in that packet. So that would be helping him maintain his benefits and find part-time employment so that we can have a best course of action for him to actually have some amount of savings, some amount of income, so that this can be a sustainable plan.
Y'all said a lot, but I got a question.
Yeah, and I have some more to add. I just wanted to pause
The
to see if
bottom
you did have
line in
any
this-
questions for me.
Is the bottom line in this case, and anybody who can answer it, is the bottom line in this case that if we release him, he's going to be homeless?
That is correct. He's going to stay at the Oz where he has stayed before in the past. He's going to work with Christy Arsenault, his housing case manager. He's going to have a bigger income because we're going to help him with the benefits and part-time employment. And then on top of some other services that you've heard from, with him being a prior client at First 72, with him having sought help at the Day Reporting Center, this story is different because as his client advocate, I'm actually around to help him manage all of those things. You can imagine that when you're getting out, you know, it's hard to keep up with your appointments. You may not have bus transportation. You may not remember all your appointments. And I'm gonna be in that picture and staying on top with Mr. Davis so that we can keep everything organized and actually facilitate all those various service providers.
I just will say, I'm frustrated by the fact that he had services from first 72, and yet we find ourselves with criminal conduct, whether it was simple battery or whatever. And do you understand my frustration? Just hear that. I don't want any comment on it. I just want you to hear that.
Can I call executive session, please? Second.
I'll agree.
Barrow,
Yes.
Ledoux,
Yes.
Phillips.
Yes.
So we have.
They going back about it.
Huh?
All right, we're gonna come back out of executive session with no objection. We're gonna turn it back over to Mr. Tillis to continue his line of questioning.
I'd like to see if the attorney has anything else he would like to add to this.
Apologies, my Zoom froze for a moment there, but I'm assuming you were asking. Can you hear me all right?
Yeah, you have any other questions?
Glitching
or-
in and out. I'm not with me if
Can you hear
sorry.
us now?
I can hear you now. Yes. Can you hear
Yeah.
me okay?
Yeah, we hear you okay. Are there any other questions?
Notification that my internet connection is unstable. It might be better for me to just go until you notify me that you can't hear.
Go ahead.
Okay.
But y'all can hear me okay. All right. Regarding some of the board's earlier concerns that I had heard, I would want to point out that Mr. Davis has not had any of these reaching out to serve parts of his parole. The day reporting center has not been a mandated part of his parole, to my knowledge. Reaching out to the first 72, I think, in the first place, to start to replace his documents, to get his birth certificate, to get him on the path of getting those documents, I think shows initiative on Mr. Davis's part that he was attempting to access services. He just didn't have the extent of the services that he needs. And I would indicate that Sophie and Wanchi have both presented a plan that can put him on a path, a better path to success. I understand the board's concerns regarding his housing. I wish it wasn't the case that in order to get a housing voucher, you needed to be homeless. I would indicate that if that is the board's main hangup, that Mr. Davis, if Mr. Davis needs to go into a transitional program, if he needs to go into a group home or into sober living, I think that would be preferable to it would be preferable to incarceration, and eventually he is going to be released to the streets. At some point, his time is going to be up, and I think it's best for him to be released when he has Wanchi, when he has Sophie, when he has people who are behind him, who have created this structure for him, and who exist as points of contact for him to go back to if things start to fall through, if they start to unravel. Regarding the charges in this case, the dropped charges, I would just note there are 2 dates alleged and 3 charges from those 2 dates, as far as I can tell. There is disturbing the peace, simple criminal damage to property on January 1st, 2026. Those charges were in municipal court. I did not represent him on those charges, but it is my understanding that they were dismissed in May. I thought they had been dismissed earlier than May, but it turns out, based on paperwork that I was able to view from my colleagues who pulled it, that those charges were dismissed. The charges that he has been incarcerated on since February 17, 2026, as I stated earlier, is 1 count of simple assault. Those charges were refused, as was documented in the parole packet that I submitted. I did have access to that dissolution because I was the attorney on that case. I would just note that Mr. Davis, I think, would agree with me when he said he got into a relationship with a woman who was not good for him. I think that he was seeking support. He was looking for stable places to be, and he thought he might find it in this woman, and he did not find it in this woman. And I think that there's no allegations of physical harm to her. I think that from my research into her, she has a history of alcoholism, and I have not been able to access court records, but I ran a background check on her. I found allegations of driving while intoxicated as recently as 2021. And this is just not a person that Mr. Davis should have been in a relationship with. It's not someone that he should think. I think, Ms. Davis, you can speak for yourself. You would agree with me that she was not a good person to get into a relationship with, and he knows that now. He has now spent 5 months in custody with 5 months with nothing but time to reflect on the fact that he should not have, this is not a person he should have gotten involved with. Simple assault is the charge that was referred to the district attorney's office in New Orleans. 1 count of simple assault. Aggravated assault, also a misdemeanor, the maximum amount of time he could have served on that, if he had been found guilty, would have been 6 months. On a charge of simple assault, the maximum amount of time is 90 days. He's been in almost 5 months at this point on charges that were all dismissed. I do not know. I have never met the complaining witness in this case. I have been able to research to the extent that is possible from publicly viewable information that it seems as though there's been issues with NOPD in terms of what she reported. It seems that maybe, I don't know if there was, NOPD used their discretion to only refer one charge of simple assault in February to the district attorney's office. That's what the official court record states. I don't know if there was an error in terms of the number of folks they saw that day, if they accidentally put allegations into one report when writing another, but the public record says very clearly simple assault. And I would just note the max is on a simple assault charge would be 90 days. In conclusion, I think that Mr. Davis, he needs support when he's released, whenever he's released. Whether that's at the end of his sentence or now, he's going to need that support in order to be successful on the outside. And I think that he attempted to access services to the extent that he could, and it fell apart. And he's in a good position now with people who are committed to supporting him, who are committed to making sure that if he needs to go into sober living, if he needs to go into a structured program, he will do it. If there are requirements that the board wants to put in place and say, we will not lift this hold until you have confirmation that he is going into a 90-day program, into a 30-day program, just some kind of structured step down, he will do that structured step down. But at this point, we are asking for you to exercise your mercy today and to release Mr. Davis back onto parole. Thank you.
Thank you so much. Any other questions? I'm ready to vote. In lieu of what happened, he did make violations or create some violations, and today my vote is going to be for rule number 3, 4, 5, 6, and 9. My vote is going to revoke.
Mr. Davis is a 5th felony offender with GWI 4th, and has continued to not adhere to conditions of parole. My vote today is to revoke.
And I concur with both my colleagues for this, all the same reasons. Mr. Davis, today your parole has been revoked. We'll be ending our interview today at 1:31 p.m.
People
Committee on Parole is called to order. Today's date is June 11th, 2026. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis to my left and Ms. Ledoux to my right. Panel today is at headquarters, Baton Rouge, Louisiana, and our remote location is the St. Mary Parish Jail. We're doing a parole hearing on Mr. Blaine Green. Mr. Green, would you please introduce yourself with your full name and DOC number for the record?
My name Blaine Keith Green, DOC number 565-739.
All right. Your case has been assigned to Ms. Ledoux, who's going to take over the question.
Okay, Mr. Green, you have two attorneys today. Mr. Ferdinand Valtu?
Yes. How you doing? Good afternoon.
Good afternoon. You're the attorney representing him, the appointed counsel for the case?
That's correct.
And Ms. Elizabeth Cumming, would you please tell us a little bit about your presence today and your role in this hearing?
Yes, good afternoon. My name is Elizabeth Cumming. I work with the MacArthur Justice Center. I and my office represent Mr. Green in a civil case arising out of an incident that occurred at Madison Parish Correctional Center. I'm happy to talk a little bit more about that now or later on in the hearing as is useful for you all.
Okay, I think a little bit later we'll hear from you. I will ask Mr. Valtu that you assist your client as necessary. I understand he has some factors which may need assistance from you. Okay?
That is correct, and I appreciate the opportunity. I think he will need my assistance. I'll be here to help him.
Okay. All right, Mr. Green.
Yes, ma'am.
Okay, I'm going to be reading some information, and these are the reasons that you're accused of violating your parole. And I'm going to read those, and I'm going to ask you for a plea of guilty or not guilty or guilty with a statement. Okay?
Yes,
and if
ma'am.
you need help, then your attorney can help. Number two, you're accused of not reporting for an in-person visit to any parole officer since 2/28/25 when you were contacted at the Avenues Recovery Center in Metairie by agents of the East Jeff District of Probation and Parole. After that, contact was made in Franklin City Jail in April while you were in custody for the misdemeanor theft charge. And after leaving the Avenues of Recovery, you didn't contact anybody. You were given instructions to go to someone after you got out of the Avenues program, and you did not do that. You failed to be located at your residence on Josephine Street in Franklin in June and July. And because of that, a warrant was issued 7/9/25. They didn't see you until you were arrested again on October 15th and charged with remaining where forbidden. How do you plead to that?
I would tend to plea of not guilty on behalf of Mr. Green to that charge.
Okay. Now, also, number 4 has 2 parts, and they're criminal conduct. You engaged in criminal activity on 4/14/25 when you were arrested by the Franklin Police Department and charged with shoplifting. And then you pled guilty to that, and you spent 15 days in city jail. How do you plead?
I would plead on behalf of Mr. Green, not guilty. We filed a motion that I forwarded yesterday to the board that's in contemplation of removing that guilty plea. We can go into it further, in depth.
Of inability to, okay.
Okay.
And number 4, you were arrested again 10/15 when you were charged with enter and remain in a place or land after being forbidden. And those charges, are they still pending?
No, those charges were dismissed. I think
Okay.
I've submitted the court entry, some court minutes to the board.
I'm sorry if I haven't looked at that. And that would be a not guilty plea. The last
Correct.
one is 10 regarding his fees, $1,071 in arrearage of his supervision fee.
Yes, and we would tender a plea of not guilty to that also.
Has he paid his fees?
He has some extenuating circumstances. Mr. Green is disabled. He was in the process of receiving disability. He's not able to work. He's attempted to work several times because of his mental health challenges. He's not been able to maintain a job.
So we have his mother and his sister here are on Zoom. Miss Deborah Green, mother, would like to speak. Miss Green, if you'll go ahead and address the panel. You're on mute. If you can unmute, that would be great.
Okay, yes, I'm the mother. Thanks for having me on behalf of my son, Blaine. With him not going to see his, I was the one that was voluntarily taking him. He went a couple times, and then after that, he started getting paranoid, like schizophrenic. He was scared that if he go there, I don't know, lock him up or something. I kept telling him you didn't do nothing. So each time I go to get him, to bring him to go see the pill, and then he would get the glazing and thing and sleep all day. And when he do get up, his eyes look, he glazing, scared, like he just seen a ghost. So I on my behalf, it was which I should have called the probation or somebody, to let him know, because I went a couple of times with him because I was the one that bring him. But like I told the attorney, he listens to me, and think I can get him to do things, but he more closer to his sister where he'll listen to her. So that's why I told me she would be the one that can get him to go, as we work as a team, to get him to his probation officer and to see his probation officer, to his doctor's appointments and everything. She would be the one to, the get him to go faster, quick and faster, talk to him and then get him to go see him and bring him, and thing. And she is right here on side of me, I think. And he only got like that, like with all this mental, it's so much with all the mental problems he's dealing with, and thing. I tried to thought I can keep it under control, to keep him, for going to see his PO and trying to explain to him why he have to go and thing. But with the mental issues, it was like he was scared. He was scared that they was gonna lock him up. Then when they jumped him and beat him to death, that made him most scared. I stayed up all night, every night, dealing with this, because he don't sleep. He's scared to death. I got to sit up.
Let me ask you something. You said you had to go pick him up and take him. Where was he living? He was not living with you.
Yes, he was living with me.
Okay.
Let's see what
Yeah, there is Brittany Green, the sister.
Right.
I'd like to hear from her now.
Okay.
You wanted to speak?
I was just speaking to let that he helped my mom around the house, and that sometimes he forget like his doctor's appointments, and that he got appointments to go see his PO, and like he be scared half of the time. He could just be sitting down and he looked like he's scared, like something to scare him. And he is a good helper around the house and with the kids, and he'll have support to get him to be better organized with his appointments and take him to see the probation officer and just make sure he's taking his medication and stuff,
And he have housing.
and going to counseling, and he have housing and stuff.
Okay, thank you. If Mr. Valtu would like to speak to the situation at this time, it would be appropriate.
Sure. I would. I've submitted to the board a letter from Ms. Courtney Clemens, who's Mr. Green's mental health treatment provider. And she testifies, I think if you have it in front of you, that Mr. Green is a patient. He has a diagnosis of schizoaffective disorder, bipolar type. He suffers from paranoia, delusions, and auditory hallucinations. These symptoms and his past experiences while incarcerated led to his aversion to meeting with his parole officer to address the first alleged violation. I've also submitted the video of the beating that Mr. Green received while he was incarcerated, and the result. I've also submitted the medical records that resulted from that beating that he received. I think he's got a metal plate in his head. He's got a scar. His mother testified, as well as his sister, Miss Brittany, that Mr. Green already had mental health issues prior to that. But after he was beaten severely, and as you can see in that video, it just simply it aggravated him to a whole nother level. And those occurred before he was released on parole. When they say that he was afraid to go to see his parole officer, his mother, I'm sure she'll tell you, and I'll let her speak in a little while if you let her. She'll explain to his disposition and I guess we can say, yeah, his mindset when she would mention, hey, it's time for you to go to your parole officer. I'm going to bring you. She would say he would get agitated. He wouldn't want to go. As she said previously, that she felt that he would be locked up again and he didn't want to go back into jail, which is understandable once you look at that video and see what he endured. But regarding that, we also we filed a motion to withdraw his guilty plea. As you know, there was a preliminary hearing scheduled for Mr. Green, and that preliminary hearing had to be rescheduled in order to have Mr. Green appointed counsel. That's how I got involved, because of his mental health issues. They didn't feel he understood what was going on in the hearing, so they wanted to have an attorney. Regarding his plea of guilty in the theft case, I submitted a copy of the affidavit in that matter. He was alleged to have taken a plastic container of candy. We filed a motion to vacate that guilty plea on the basis that, number one, he did it without counsel. I don't think he fully understood what he was doing by pleading guilty. I think based upon what his mother told me and what he told me, that he was advised by other fellow inmates prior to going to court, yeah, that's just a misdemeanor. Just go ahead and plead to it. You'll be all right. I don't think Mr. Green recognized or realized that he had a parole. He was under parole, and that if he pled to something like that, he could revoke it. So now I think that, like I said, all of these problems that he has stems back to his mental health history, particularly what happened after that beating he received in jail. And like I said, you can see in that video, he was attacked by 15, 20 people. It was a mob strictly against him. And I think that set the tone for everything subsequent to that. How his reasons why he didn't want to see the probation officer was, making the connection that seeing a probation officer is an authority figure that could put him back in jail. He didn't want to experience that again. The fact that his mental issues precluded him from understanding the consequences of tendering a guilty plea to a misdemeanor offense, and just in general. So I think that, what we're dealing with in this case, and I think that the mother said, and Miss Brittany, his sister, said that should he get out, should he be allowed to be released on parole, he will be living with his mother again. Brittany, his sister, will be assisting him further, and I think they're going to intensify their efforts to make sure that he gets to his parole officer, that he's covered, that he's taken care of, as his mother said. But I think he's going to have a team of people, his mother and his sister, that are going to, should he be released, they'll make sure that he does what he's supposed to do, see his officer when he's supposed to, and keep him out of trouble. I think Mr. Green understands also now, having spent several more months in jail, the possibility of what could happen to him should he be revoked and where he would be at again. And I know he's not happy with being in jail right now. I visited him a couple of times, several times. I noted his demeanor, and yeah, I think he's willing to, and I think he's ready, and I think his mother and sister are there to help him and assist him to be successful on parole should he be released again.
Elizabeth, or should I say Ms. Cumming, because of it, this being a legal issue on the civil side, I don't know that that really is going to play into my decision, because it's, I think it would be really inappropriate for me to take that into consideration in a revocation situation. So I appreciate you being here. I have read the reports, watched the videos, read the reports from the psychological team. I think that we're going to go ahead and dismiss from having you testify, if that's acceptable. Okay.
Yes, ma'am. Thank you.
Mr. Green,
Yes, ma'am.
do you know that you cannot take things that don't belong to you when you're out?
Yes, ma'am. Yes, ma'am.
Do you know that you can't go where you're not supposed to go?
Yes, ma'am.
Okay, Mr. Green, I know you have some issues and you've got some struggles, but you have enough understanding to know that you've got to follow the rules while you're incarcerated and when you're out, right?
Yes, ma'am.
Okay. Do my colleagues have any?
I'd like for the executive session.
Okay. Who's second? Who's second? Barrow?
Yeah.
Badoo? Yes, Phyllis.
Yes.
All right, we're going to return from executive session without objection and turn this hearing back over to Ms. Ledoux for the vote.
Okay, I believe that we've reviewed everything in great detail. Today, my vote is to not revoke Mr. Green, to allow him to continue on supervision. Mr. Green has not shown any violent tendencies since he was released. I would also like to make the recommendation that he have the parole officer do monthly meetings at his home and not required to go into the office to diminish any concerns there. And that he continue to receive mental health care until his end of his term.
Mr. Tiller.
I concur.
All right, I'm going to also concur with that, but I'm going to also add a condition that you stay away from the victim in that case, Dorcia Bland, and you not go back to the store where the shoplifting occurred.
Yes, sir.
You know what I'm talking about, right?
Yes, sir.
Don't go back over there.
Yes,
And
sir.
you're going to have to report to your parole officer is going to report to you, but you got to make yourself available.
Yes, sir.
All right. Sounds good. With that vote, your parole is going to be reinstated and with special conditions we just talked about. This concludes our business today at St. Mary Parish Jail at 2:05.
All right.
All right. Thank you very much.
Thank you.
Thank you.
The Committee on Parole is called to order. Today's date is June 11th, 2026. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis to my left, Ms. Ledoux to my right, and our remote location is TANGIPAHOA Parish Jail. We have any staff in the room? Would you please introduce yourself? Are there any staff members in the room with you?
No, sir.
All right. Well, introduce yourself and give us your full DOC number for your record.
My name is Derrick Austin, DERRICK AUSTIN. My DOC number is 783389.
All right. Do you have the parole revocation questionnaire in front of you regarding appointed counsel?
No, sir.
Do you remember signing it with the probation and parole people?
Sir.
Can you put it up there for me? We can put one up on the screen for you to see. At that time, parole officers determined that you were not eligible for appointed counsel based on those answers. Do you recognize that now?
Yes, sir.
That's your signature down there at the bottom?
Yes, sir.
Okay. So basically what that means is that they determined you're not eligible for appointed counsel for the purposes of this hearing. If you don't want one, you could hire one. Did you hire anybody?
No, sir.
All right, so your case is assigned to Mr. Tillis. I'm gonna go ahead and turn it over to him to ask you the questions about the violation.
How are you, Mr. Austin?
I'm good. How about you, sir?
Good, good. I'm going to read some violations, and you can plead guilty, not guilty, or with a statement. Violation number 2. While attempting to speak with the subject on the telephone, Derrick Austin told me, Agent White, that former agent Preston Bennett was his parole officer. While advising him of the change, subject stated that he would contact a Meek District's office and then end the conversation in the middle of speaking to me. How do you plead? Guilty, not guilty, or with a statement?
Yes, sir. And when I first heard this, when I had my preliminary hearing, I was under the impression that we was only going to be talking about the dismissed charges. I didn't know that these other 2 items was coming up, so I pled guilty to that previously. But I would have to say not guilty now, and the reason being, Mr. Jamar White was my 3rd parole officer. My first parole officer was Mr. Chad Boham. When my parole officer switched from Mr. Chad Boham to Mr. Preston Bennett, Mr. Chad called me and he said, "Hey, Derrick, look, I'm giving you a heads up, letting you know that you have a new parole officer. So when he contacts you, it won't be any problems, you know, and if you need anything, feel free to give me a call." I had a great relationship with Mr. Chad. That process went seamless. I had a good relationship with Mr. Preston. Now, Mr. Jamar just called me out of the blue, and to be honest, I didn't believe him when he said that he was my new parole officer, and that call was ended. However, I told him, I said, "I'm going to call the office and verify that you are my parole officer, and then I'll call you back." I have phone records to prove that Mr. Jamar called me. I called the office, and immediately I called him back. So that did happen like that. But what was left off was I called the office and then I called him back. And I have the phone records proving it.
Hey. At any time that some of you members want to ask a question before we go to the next one, let me know. Violation number 4. The subject was alleged involved in criminal activities which led to a warrant being issued to his arrest by the Southeastern Louisiana University Police Department for domestic abuse battery. He was later taken into custody by Southeastern Police Department. The charges were rejected by the 21st Judicial District Attorney on 3/23/26. Per an advocate affidavit completed by Crystal Austin. How do you plead? Guilty, not guilty? Or with the state?
Not guilty. I mean, the charges was dismissed.
But did you engage in abusive battery?
No, ma'am. No, sir. No, sir. I never hit my wife, and she's here on the panel today. I never hit her.
Okay, tell us what happened.
The long story is, we have been under a lot of stress, man. From the end of 24 to 25, my mom came down with severe dementia. I had nobody else helping me. I was doing it all on my own. It led to a lot of pressures being put on me and my family. And what I am guilty of is falsely accusing my wife of doing some things that she didn't do. But I never hit her. We had a tussle over a cell phone, and it was kind of a tug of war type deal. And I let it go. And when I let it go, she hit her head on the, we was kind of positioned in a car, like under a tug of war. It was a real tug of war. And I let the phone go, and she hit her head on the window of the car.
Okay. Violation number 7. While speaking to the subject on the phone, he advised that he was on the highway traveling out of town. Approximately minutes later, the subject was caught on camera visiting his victim's parents' house to see his children. How do you plead? Guilty, not guilty, or with a statement?
With a statement. I was traveling, I was coming from Baton Rouge.
Guilty or not guilty?
I would say not guilty, man. I would say not guilty because I don't know what times he's talking about. I was in Baton Rouge when he called. When I called the parole office, I was in Baton Rouge at the moment. When Mr. Jamar first called me, so I don't know exactly what he's talking about. Minutes later, I was on a video. That's why I would say not guilty, man. And not just saying that he's lying. I just don't understand the time frames he's talking about. I was in Baton Rouge.
Did you notify him that you were leaving? Is it out of state or?
No, Baton Rouge is 30 minutes from my house. I live in Holden. Baton Rouge is one city over.
I got you.
And I was at my brother's service out getting some work done to a car.
All right.
I never went out of state or anything like that.
You're right. I understand now. Violation number 10, subject is currently $836 in arrear on supervisional fees and $65 in processing fees. How do you plead?
Now, with a statement, because I do have a past due balance. And like I said, in the 24, 25, man, I went through a whole lot with my mom with severe dementia. It got to the point to where she couldn't stay at home alone. She was leaving out. I would have to go and find her. So I eventually got her to my house. I was talking with Mr. Preston, and I let Mr. Preston know, man, I'm having some hard financial times right now. I'm behind. I'm probably going to go a little bit further behind. But once I file my income taxes, I'll catch everything back up. Mr. Preston was fine with that. And he told me, he said, man, look, he said, I don't care about fees. I get paid either way. Just don't make me do my job. And I didn't take that as him saying he did not want to do his job. I took that as him saying, stay out of trouble. And he went as far as even helping me look for resources to help me with my mom. And it was because of Mr. Preston that I eventually found an investigator with the elderly affairs who ultimately helped me get my mom into a nursing home with a memory care facility. I got my mom into a nursing home the end of October. I was about to start doubling and tripling up on my payments in November, but I ended up in jail in November. My mom, once I got my mom, once I started going through my mom's stuff and I started figuring out this dementia thing, Coming to find out she was months behind on bills and she just forgot to pay them. And it just put me in such a bad financial strain. But I communicated with Mr. Preston all the way through this, and he was okay with me waiting till tax season to catch this up.
Okay, so you're pleading guilty with a statement.
Yes, sir.
Okay, that's good. We'd like to hear from Ms. Austin now. Crystal Austin. What would you like to tell us about your husband?
Hi, good afternoon, everybody.
Good afternoon.
So thank you for allowing me to have this moment to speak with you. I'm Derrick's wife. I am also one of the reasons why we're here. People will call me a victim, but I wouldn't call myself that. I would call myself a survivor. I would also call Derrick a survivor as well. So I don't particularly, I'm here to talk about the events that occurred, but I want to speak in support of Derrick. And I did write a few notes so I can remember what I wanted to share with the board today. So I've known Derrick for 24 years. We have been married for 10 years. Our journey has been a love story. We're not perfect. We have not been perfect, but we have managed to overcome some difficult seasons together. And this past year has been quite the most difficult for us, but it has been a culmination of some poor communication, some misunderstandings, some disrespect on both of our parts. And on top of that, like Derrick has shared with the board, how his mother has been battling with dementia and how we were caring for her in our home with her rapidly deteriorating with that disease. So it's easy to say how, someone would cope with such stress and past trauma until you're going through that kind of a situation. And yes, a lot of things that we have done could have been handled differently. And this past recent events that we have been through is not a normal part of our lives. This is not something that's part of our relationship or what has, what goes on in our lives, individually or together as a married couple. However, I am a godly woman. I am a praying woman. I believe in healing and restoration. I believe in forgiveness. I have forgiven Derrick for all the things that he's done, and I believe that he has forgiven me for the things that I've done as well that has not contributed to, the health of our relationship too. One thing that I know Derrick can attest to is my strong belief in God, and this one scripture that I've always kept in my heart and in my mind, and that's Romans 8:28. For all things work together for good to them who love God and those who are called according to his purpose, right? If I, say it in a short way. But I would say that is something that I've kept on my heart, something that I believe deeply. And I do believe that sincerely. And I know Derrick is not a troubled individual. He is a human being coping with pain, just like many of us are coping with pain. And with that being said, Derrick has so much love and support. Derrick has so much love and support available to him. He has other family besides me who love him, who are supportive of him, who want the best for him. We have access to mental health and spiritual support. We were actually in the midst of both individual counseling and marital counseling as well. So we do have that support and those resources available to both of us. So Derrick is not alone. He has a positive and supportive environment waiting for him. We have two daughters. Our daughters are 9 years old and 7 years old. Derrick has always been a great father to them. Our youngest daughter even called him her superhero. So, he has always been a great father to him. But our family has suffered enough, I believe, while our children have been shielded from this latest ordeal. You know, things can still be hard. They don't really understand or know what's going on. They have remained their innocence, joyful selves, full of love and light. But a continued incomplete family is not what I desire. And I don't think that's what's best for us as a family. It's not the best for us individually, and I don't think that's best for society as well. A broken home fuels more brokenness. So I have all confidence in saying that Derrick's release, if the board is willing to do so, will benefit all involved. You know, instead of it being a mistake, I believe that he will be the man, the husband and father that I know he is. And I just, again, thank you for allowing me this time to share. And I pray that you really consider the things that I've shared as part of you making your decision.
Do you mind if I ask you a question?
Go ahead, go ahead.
Sure.
You were estranged from him at the time that this incident occurred, is that correct? You were not living with him, you were living with your parents.
We were living together. I left and went to live with my parents after this incident.
So it was your mother who took you to the hospital after the incident, as you called it, happened.
Yes.
Okay. And are you saying that you plan to get back together with him, or that you will not be maintaining that relationship?
We plan on working through this situation together.
Okay. You know, we have the report, we have, you know, the fact that you did mention that this was not the first time, that there had been other incidences where violence had taken place. So
around this time frame, yes, I'm well aware, and you know, I've made my statements, and yeah, I'm well aware of anybody's concern that regarding this, you know, this situation, and I am speaking freely and honestly, and I truly believe in Derrick's ability to turn this around.
So basically, you're not recanting your story about what happened. What you were telling was the truth back then. You just want another chance at it.
I'm not recanting anything. In all of the reports, I did say that I did not fully remember, and I still don't fully remember the incidences that happened in that car, which was stated in all of the statements that I made in the reports. But no, I'm not recanting anything that I've stated.
Well, there was a lot of details in the report before you actually went blank. You know, there was the harassment at the school and not going away, and then there was 5 times that it's happened before, and there's a bunch of other stuff that's concerning, even if we just would drop out the part about you hitting your head, how it got hit and how you don't remember. After you left because you were scared of him. He's been in jail since then. What makes you not scared of him now? You hadn't had a chance to actually really have any interaction with him. Why are you not scared anymore?
Just from the sense that I have from him, from our latest ability to be able to have a conversation. I do know that he has changed his ability to, has changed his thought patterns, his mindset. And I mean, with anything, it's actions that's ultimately going to show. But I do believe I've known Derrick, like I said, for 24 years. And I know this is not someone that he is that does things like this. I do know that he has been going through a hard time, and I'm well aware, and from a professional standpoint too, you know, from my own background in professionalism, I know that the risk that is involved with these kind of situations, but every situation is individual as well. And so that's what I was saying about that.
Crystal, are you afraid of him?
No, I'm not afraid of Derrick.
Are you sure?
Yes, I'm sure.
Do you love him?
I do.
You're trying to keep your family together?
I am.
That's good. What's your profession?
I'm an assistant director, counselor at Southeastern Louisiana University for the Student Support Services TRIO program that helps first generation college students become successful throughout their college years. So I have a master's in counseling, and I'm considered a national certified counselor in NCC.
Oh, that's good. That's good. Derrick, you might have some questions for her?
Hey, I got another question for her. You would say you're 100% not scared of him right now?
Correct.
And if we were to release him, y'all would want to live together again?
We are working towards that.
Is that what you want to do?
It is. I'm certain of it.
Say working towards it, what you mean by working towards it?
Whether
There's something else that would keep it from happening besides him being in jail right now?
You don't have to answer everything.
No,
You're not on trial here, okay?
I'm just trying to figure out if this is a good thing for you. We want to make sure you're safe.
That you're safe.
Yeah. And yeah, I definitely feel safe. I would say this. I ultimately, as y'all know, I dropped the charges. If I felt anyways unsafe, I wouldn't have done so. So I do feel safe. I do feel okay if the board does decide to release him. I don't feel in any ways afraid for my life. I don't feel afraid for my children's lives. I don't believe Derrick would do anything harmful to them or to myself. Yes, we did go through a hard time, but I don't believe that he would do anything like that further.
So you said that y'all had tried some counseling. Was that together or apart? I didn't quite understand what you went and he went, or y'all went together? How was that? What was the plan with that?
So both. So I've been going to counseling. He started individual counseling as well. And then we started marital counseling together.
And y'all started that before he went to jail, before this all blew up?
Yes. So it was only a few sessions that we started before November.
That would probably be a good thing to continue.
Sure. Yeah.
That's what you believe? Yeah. Was he cooperative with going to that counseling back then? Or
Yeah, he was. He was cooperative with the marital counseling, and I was surprisingly happy he was cooperative with the individual counseling as well. So and I don't think he would object to going to individual or a supportive group or marital counseling in the future.
All right, that's all the questions.
Thank you so much. Derrick. What are you trying to do to better your relationship with your wife?
And I was wrong for a lot of things that I did. I take accountability and responsibility for that. I was accusing my wife of things that she could not do. I was being totally unreasonable, and I'm sorry for that. What I'm doing in the future is, this time in jail, I did a lot of writing and a lot of writing of thoughts, and it actually brought me back to my childhood, just random thought writing, and I found some issues, and I started talking to my wife about it, and she said that from this now I can start to heal. So I want to continue counseling. I was totally against counseling at first before we started, and she kind of pushed me to go. I want to continue counseling. I want to go to counseling, and I want to dig into some of these recent discoveries that I found.
How do you feel about your daughters?
Man, I love my daughters and Crystal more than life, man. I call them my three girls. I miss them so much.
Have you ever had anger management?
No, sir. No, sir. And I never had anger management. I never had anger problems. I believe these incidents was isolated incidents. I was under a lot of pressure. This is just what I believe. Like I tell Crystal, I do want to go to counseling, you know, but just from my perspective, what I believe, I was just under a lot of pressure, man. And watching my mama deteriorate, I know you see tears falling, like it's hard for me to even talk about it because I never pictured my mom in this light. When me and my wife went to go and see her before I came to jail, I couldn't even talk to her. As soon as I sat down, I started crying. So I've been under a whole lot of pressure, man, and doing this by myself, you know, with my wife. But continue going to counseling and continue being a father, man, and a husband, man, and give my wife the love and respect that she deserves, man, because she don't deserve nothing less.
You said just a little minute ago that you worked through some issues, you figured out what your issues are. What are you? Is it mental health, substance abuse, drug abuse? What is the issue?
No, it was some abuse that I endured as a child that I found out about, that I've been hiding my entire life. I've been hiding. It's always been in the back of my mind, but I just hid it. And it came out on this paper, and I told my wife about
it. Right.
And it was amazing. It was really amazing once I told her about it, the weight that it kind of lifted off my shoulders, just bringing it to light.
All right. You pretty much answered all the questions we have. We're prepared to vote. This case is assigned to Mr. Tillis. Let him go with the first vote.
Mr. Austin, I'm gonna hold you responsible to be a better person. My decision is you have a good wife, real good wife, and I hope you realize that. And I hope two beautiful daughters, you know, keep the family together, do the right thing. My vote today is do not revoke.
Yes, I do.
Oh. You need domestic abuse battery classes. I know that you've had some substance abuse treatment because you were positive right after you got out of jail the last time. They sent you to a program, right? So I think you've got some things to work on. I'm not sure whether you need to do that while you're incarcerated or you can do it on the street. But my vote will be to not revoke, but you must have domestic abuse battery class. You have to immediately enroll and you have to complete that And it's a long class. Okay, and you're gonna have, increased drug screens just to make sure that drugs are not contributing to your behavior.
All right. Your wife convinced us, so you owe her.
I'm not real convinced.
With good behavior, well, she convinced me, you owe us by giving her the respect and behavior that she deserves. Let me rephrase that. She didn't convince me that nothing happened back then. I believe everything that said happened, probably happened. But, I'm gonna go ahead and concur with, the colleagues here, but I'm gonna require you to attend the marriage counseling apart and together. The whole program that y'all had lined up that went south, I want you to start that over again, apart and together, and successfully complete it. And I'm also gonna add the anger management class after the domestic battery class. We're gonna have you to, if you go through all them classes, you're gonna work out all these problems and anger management that you got and be a much better person. And if you don't, well, you don't even have to wonder about what's gonna happen next round. So what it means is by a unanimous vote, we've agreed to reinstate your parole conditionally with all of the stuff that each of us told you. And wish you well.
Thank you.
Good luck to you.
Thank you all.
This will conclude our business today at Tangipahoa Parish Jail at 3 o'clock.
So much for going in order. All right, you gonna stand aside until they come on. You might as well not even send that goddamn list out. Don't know what they want anyway. St. Mary was after us. Tangipahoa was actually first. And they were first, and they saw them just before us. Let's see who they did at top.
It always stay down.
Do what?
It always stay down.
Huh, they muted me back. I thought they were listening. They didn't want to hear what I had to say because I unmuted it. What you said?
And it always take that long.
No. This is a record. This is a record. I've never been to hear this thing. But this is how it comes up, so you'll know. That's like when you got 3 and 4 of them, like if you do it by the second floor I showed you, you got that holding tank right there. That's where you sit them till they're ready, and then you bring them in one at a time. This gives you a little time to go get you in there.
So why the fuck we didn't do that?
Today's date is June 11th, 2026. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis to my left, Mr. Adu to my right. Panel's at headquarters in Baton Rouge, and our remote location for this hearing is Jefferson Parish Correctional Center. Is there any staff in the room?
Yes, sir. Deputy Ivy Marlboro, Jefferson Parish Sheriff's Office.
Thank you, thank you. And we're there for a hearing on DARTANIA ETIENNE. Would Mr. Etienne please introduce himself and his DOC number for the record?
My name is DARTANIA ETIENNE. DOC number is 566166.
All right. You have your parole revocation questionnaire in front of you?
Yes, sir.
And at that point, it was determined that you were not eligible for appointed counsel by the preliminary hearing, which would mean that you're not eligible for the appointed counsel for this hearing also. Would you like to continue?
Yes.
All right. I'm going to turn this case over to Mr. Tillis, who's going to do the questioning.
Mr. Eaton, how are you?
I'm doing okay.
Good, good. I'm going to read some violations and you can plead guilty, not guilty, or with a statement. Violation number 4. You violated the conditions when you were arrested on 4/9/26 by the Jefferson Parish Sheriff's Office and charged with stalking, resisting an officer, and is currently incarcerated at the JPC office. Misdemeanor stalking was by the DA's office. Case number JEF-261729. Subject pled not guilty and is set for a pretrial hearing on 6/22/26. How do you plead? Guilty, not guilty, or with a statement?
Not guilty with a statement.
Tell us what happened.
What happened on that following day, I had got arrested. I was going to my ex-house to drop off a card and some flowers. And as I got to the house, I had parked my car and I was sitting in my car before I got out. I had lit up me a cigarette by the smoke to grab the stuff so I could be able to get out. And as I was about to grab the stuff, another car had approached in the same parking lot and parked right in front of me, across from my car. And then as I was looking at them, they came approach my car and told me, get out the car, let's fight, woo, whatever. Then they backed up from my car, went back, and they blocked my car in. So I pulled out and I left the complex. So when I left the complex, I had came back. And when I came back, I was walking through to go talk. And when I came through, the police was out there. So I guess somebody seen me walking through the apartment complex and told the police where I was at. They came towards me, apprehended me and stuff like that.
Did you resist an arrest?
Well, I was trying, like, he was like telling me to stop, trying to detain you and stuff like that. I told him, look, I don't mind detaining, but we ain't about to put no handcuffs on me like that. I said we can talk and I'll tell you exactly what's going on and things like that of that nature.
Really understand.
Yeah, could you repeat that one more time? You didn't like the way he was going to put the handcuffs on you?
Like when I was walking, like I was walking through the apartment complex and he told me, come here. And he like, what's your name? I'm like, I'm just about to go back to my car, whatever. He like, you're not under arrest, you're being detained. So he kept saying, put your hands behind your back, put your hands behind your back. I said, if I'm being detained, well, I got to put my hands behind my back. You know what I'm saying? Then like when I was walking backwards, another cop just came from behind me and just grabbed me and slammed me on the ground.
There were 2 police officers there?
They had a few cars out there in the parking lot.
Oh, okay. The lady you were going to see, who was she?
That was my ex.
Oh, okay.
We've been dating since 24, you know what I'm saying?
I see. How long?
Go ahead. If she was your ex, what were you going to do?
Well, I'm saying like, we was dating since then, and like we had an altercation basically. Like, you know, we was talking and like I probably said some things and she'll misunderstand it and she'll take it the wrong way and she had gotten mad. So, you know, I let her get a little mad and I just said, you know what, I'm gonna just drive by her to bring her the card and flowers to make up, you know what I'm saying? to cause the confusion now, because you know, basically since I've been out, you know, I had my own apartment. She used to always come over there by my apartment, instead of being at our house and sleep over at my house.
The police report says that
I know that's why I would have to bring the cards to her house.
because your phone was blocked. She had blocked you.
Well, it wasn't blocked, she wasn't answering it. That's what they said in the report, it was blocked and stuff like that. So she'll like look at it, hit the end button, and then probably lay it on, hit me back up, call me, you know, things like that.
So it kind of looking to me like she didn't want you around there, but you were still trying to go make up.
Yeah, well.
Is that what was happening?
Huh?
You and her had broke up, and then you were trying to go back and make up with her?
Well, I know probably right now, that's how she'll probably make it look, but that's what I can see right now. That's probably how she'll probably would have made it look.
That's not how you see it?
No.
How you see it?
I would just, you know, because normally like when something like this happened in our relationship, she'll ignore me for a couple of days and she'll reach back out to me.
I didn't understand that. Can you repeat that one more time?
It's like, all right, say for instance, like me and her had like an argument, a dispute, and she'll probably block me right then and there. Then a couple of days, she'll reach out and touch and call me back up and stuff like that, and be like, "I'm sorry, what you doing?" Things like that.
But y'all had an argument. She blocked you, and then you going over there just to give her some flowers in a card and tell her everything's good.
Right? Yeah, I like through our relationship, I did things like that, you know. Just like in case we got into it, like just be like, you know what, it wasn't all that there, here go a card and stuff like that, you know what I'm saying?
Okay. All right, rule number 10, you're in the rear of $833. How do you plead?
With that one, I'm gonna say also not guilty, and I can explain it out.
Okay, tell us what happened.
All right, what happened with that? I was presently staying with my my daddy, and then I had started like trying to save money to get my own apartment. And when I did get my own apartment, my car had broke down, and my car been in the shop like 4 or 5 months, waiting on parts. So what I have been doing was I've been paying the notes on my car insurance, a rental car also, plus my bills in my house. You know, that really it really had me in a little hole in the jam, you know what I'm saying? And then like, basically like the time when this here occurred, I was getting out of the jam. I just got out of the jam. I was gonna catch up on all my bills and stuff that I had to catch up on. Cause I was really struggling, you know what I'm saying? I just was trying to make sure I had somewhere to lay my head and things like that. And take care of all my necessities.
All right, thank you. Are there any more questions?
I'm also seeing in the police report that she gave the cops like 5 notes that you had been leaving on her car. You had been going by putting notes on the car.
Well, you know, I like passed over there, you know, because I want, you know, from the last time we had a dispute, me and like the children, they don't really understand, but me, she'll just to come behind, sneak behind their back, come see me. So instead of me going knock on her door, I just put something there, she'll know it's from me, or I just drop it on her car and I leave, and that's how she'll get back in contact with me.
Okay.
My notes indicate you broke up in August of 25, and this behavior continued, and she felt that was stalking.
Well, we did not break up, because if we'd have broke up, she wouldn't be coming to sleep at my house every night.
Well, if she was going to sleep at your house every night, why were you going?
She was
to her
coming to
house?
no. Well, that was after, right before this situation had supposed to have occurred. You know what I'm saying? She'd always come to my house, and then that last little week, she had stopped coming over there.
You have a trial for the resisting officer on 6/26, or is that
for both charges?
That's right.
6/26.
Would you like to continue this hearing until after that trial is complete?
Yes.
I have no problem with it. Continuing.
That's fine. All right. Mr. Tillis, go ahead and vote.
My vote is to continue.
Ms. Ledoux?
Because that's the only thing really we have against you, and the court can decide your guilt or innocence. My vote is to continue.
And I'll concur. What this means today is that this hearing has been continued until the outcome of your pending charge, and then you'll be coming back.
Okay then.
Thank you. This concludes our business today at Jefferson Parish Correctional Center at 319